Is legal here? Legal here.
Mr. Chairman, we have now started recording the webinar, just so you know.
Thank you very much, Leslie. All right, it's now 5:45. I will call the meeting of the Johnson County Planning Commission to order. And I will read a brief notice with regard to COVID-19. Due to COVID-19 situation, we're taking actions to minimize attendance at the Planning Commission meetings. And we'll be conducting the meeting with an option for attendance online using Zoom webinar or in person at the County Administration Building. Details and instructions regarding how they can participate have been provided online, and anyone who's attending now by Zoom probably knows that exactly what those are. So the first item on the agenda is the approval of the agenda. Do I hear any objections to the agenda as printed? Oh, yes. My error. Thank you very much. Ms. Davis, if you would take roll, I would appreciate it.
Yes, sir. Michael Levin,
Present.
Mark Huggins,
Here.
Randy Hutchins,
Here.
George Lund,
Here.
James Neese,
Present.
Chris Iliff,
Here.
Dave Johns,
Here via Zoom.
Kelly Rast, present, Lindsay Grisay. I do see she is on Zoom. Lindsay, you're muted. We'll come back to her. Mr. Randall Downing
Here.
and Roger Mason.
Here.
Lindsay, are you having trouble? I do show her online.
Yeah, Ms. Grisay, if and when you can get off mute, please make your presence known. We just want to make sure that you're able to hear and to participate, because if you so desire. All right. The next item is the approval of the agenda. Is there any objection to the agenda as printed and distributed to us? Hearing no objection, it will be approved. The next item is consideration of the minutes of the previous Planning Commission meeting. Our last one that we have minutes for is September 28, 2021. Are there any objections or amendments to the Planning Commission minutes from September 28, 2021? Do I hear a motion to approve them as printed?
I'll
Been-
second.
All right. You'll have to give your name just for the record. Yeah. Yeah. Randy Downing has made the motion. Randy Hutchins
Second.
seconded. All those in favor indicate by saying aye.
Aye.
Aye. All opposed, same sign. Okay, the meeting minutes from September 28 will therefore be approved.
Just really quick, I know some of us are sharing microphones. Will you please make sure to bring the microphone close to you? We are recording through Zoom, so they'll need to hear you on the microphone.
And I'm probably the worst offender at this, but do remember to give your name when, and this is Chris Iliff talking, when you speak, so that the person who prepares the minutes can clearly identify you. Tonight, I'm going to make just a brief announcement, and then I'm going to turn it over to Mr. Leipzig and his deputies. We have, for several meetings, heard from a variety of witnesses. We have taken public testimony, and we have been inundated with paper from both people in the public and our own staff have provided this to us, and the people from Nextera have also provided us with a great deal of information with regard to this whole issue of the regulation of utility scale solar facilities. Tonight is an evening where members of the commission can talk to staff and tell them what they would like to see either amended with the proposals that have been put before us or endorsing them, however that may be. But this is the evening where this group will express some opinions. We do reserve a time at the end for public comment. We will go by the rules that have been promulgated, which is 2 minutes per person. There will be no ceding of time to any other person tonight. So we will hold people who want to speak very strictly to that 2 minutes, maybe a few seconds grace to finish a sentence, but not much more than that. What needs to happen here tonight is preparation for the public hearing that will occur in November. And at that public hearing, there will be an opportunity for comment. But at that point, we will be making motions with regard to what should be passed on to the Board of County Commissioners. So just so that the process here is clear to the members of the public who are in attendance here, the Planning Commission is a recommending body. It is not a body that has the right to create a new regulation. Those are done by the Board of County Commissioners, but they are done after consultation with and involvement of the Planning Commission after listening to our comments. So we will probably be taking tonight a series of small votes on different issues. And perhaps one of the most important of those issues is whether or not we are going to recommend that anything be passed on to the Board of County Commissioners with regard to utility scale solar facilities. Of course, we'll have comments from members of the board before that vote is taken, but we will, it doesn't have to be a formal vote at this time. This is not the public hearing where we vote on what we send on to the Board of County Commissioners, but it is an opportunity for us to give the staff who's represented here before us a sense of direction from us. And so this will be an opportunity for members of this commission to give direction to the staff. And then the staff will take that under advisement and we will make some more definitive votes at the next meeting. So that's where we are right now. And I would turn this over to Mr. Leipzig for the moment.
Thank you, Mr. Chairman. Jay Leipzig, the Planning Director. Just a couple of housekeeping items as we move forward in this process. As the chairman just mentioned, we have a public hearing scheduled for November 16th before this body, and the public will have an opportunity to comment at that time more significantly than we have as our previous study sessions, but public hearing is set for November 16th, and that's at 5:45 in this room, and to receive public comment on the draft regulations. We have also scheduled tentatively a committee of the whole, which is it's almost similar to a study session with the Board of County Commissioners for December 16th. That is a Thursday. We don't know the exact time yet. I believe it'll be about 2:00 p.m. Generally, they run either 1 o'clock or 2 o'clock. So we have tentatively scheduled a committee of the whole for December 16th, and then before the Board of County Commissioners. As I just mentioned, there's a public hearing before the Planning Commission on these regulations, November 16th at 5:45. A couple of additional housekeeping things in your packet. There were several written comments, and I apologize if I mispronounce these names, but I'll briefly go through them. Received comments from Dorothy Barnett, Carla Fanicelli, Gary Schultz, Diane Kanoki, Virginia Wirtz, David Pack, Martin Belcher, Alan Anglin, Ray Antis, Marie Hicks, Greg Cromer, Jack Wilson, and Marvin Belcher. Those were comments that were received in the packet. In addition, we also received additional comments that were emailed out yesterday after the packet was mailed. We had 4 additional comments from Leanne Antis, 6 additional comments from Joyce Whittier, comments from Wayne Robinson, comments from Stephen Clark, and also comments from NextEra that were emailed out yesterday. So with that, I did want to point out, we'd like to make a slight change to our policy in that we ask for that at 2 p.m. the day before the meeting is the cutoff for the comments to be mailed to the Planning Commission. That way we have time to copy them and et cetera. Anything received after 2 p.m. up until the day before then will be emailed out and put on the website. That way it's clear. I want to make sure that everyone has a chance to comment and the public has an opportunity to do so, but we're trying to establish some rules to make sure that's clear for everybody. I did want to point out, we have a letter from Richard and Donna Gall that was received this evening. I believe Mr. Gall is going to be speaking to the Planning Commission during the public comment, but his written comments will be mailed out in your packet for the November 16th meeting. Okay, that's the housekeeping items. And then the other thing I wanted to point out, we have, there's 3 documents that were included in the packet. There's 3 memos, or essentially two memos, I'm sorry, and then our draft regulations. There's a memo dated October 20th, 2021, that was to the Planning Commission from me, Sean Penley, and Karen Miller. There's another memorandum dated October the 11th that was distributed at our previous meeting from me, Sean Penley, and Karen Miller to the Planning Commission. And then our draft regulations, which includes additional comments from our original version, which was distributed on August the 10th, as well as in September, and then includes comments in blue from our October 26th, 2021 meeting. So those 3 documents will be referenced this evening, and this way we can kind of follow along, whether you rather look at the memorandum or look at the actual regulations. We'll have that available. The other comment that I wanted to make briefly is that the chairman had said this, the Planning Commission reviews policy implications for land use in the county. So they look at text amendments for our comprehensive plan, as well as text amendments for our subdivision regulations. The Planning Commission is a recommending body, so that recommendation would be made, and that goes to the Board of County Commissioners, but actually adopted by resolution. That's for the policy document for our comp plan or our subdivision regulations. Any application that we receive concerning a utility scale solar facility, which we have not received an application. I want to make sure everybody is very clear on that. We've not received an application, but if an application is received, that would go through a process with our zoning board. There are 3 zoning boards in the county. We have our Southeast zoning board, our Northwest, and our
Southwest.
Oh, I'm sorry. Southwest.
That's all that was left.
Senior moment there. There are 3 zoning boards in the county that would go before. They would, the application would be reviewed by that body. They would make a recommendation. There would be a public hearing on that application, and that recommendation would go to the Board of County Commissioners. So there's 2 processes. But the Planning Commission is just for the policy implications, reviewing the document when it goes to the board. The application itself for utility scale solar facility would go before the zoning board. So just wanted to point that out again. If there are questions, people are welcome to ask me additional questions about that. But with that, as the chairman had said, we have this, really the focus of tonight's meeting is to hear from the Planning Commission and hear your comments. Also, our consultant, Darren Coffey with the Berkeley Group, is available on Zoom this evening. Darren is the owner and the principal of the Berkeley Group. We had mentioned in our agenda that he was an independent consultant. He's an independent consultant, meaning that he does not work for the utility industry and the solar industry. So he has a considerable amount of experience in developing regulations like this throughout the country. And he is available this evening to kind of lead us through this discussion. But with that, for the first discussion, I'll turn it over to the chair and we'll start us off.
Right. That's fine. And I'm happy at any time to cede time to Mr. Coffey if he would like to make some comments and lead with some questions. But I think that, just to get started, as I mentioned in my prefatory comments, the first item that I think we have to consider is whether we pass on to the Board of County Commissioners any recommendation at all with regard to solar facilities. We've all seen the draft of the solar facilities that has been prepared by our staff. And they have a number of recommendations with regard to solar facilities. And the issue is whether we decide to proceed with this at all. Now, we can do this in a number of different ways, and we don't all have to agree. But we do, I think, have to come up with a recommendation by a majority vote as to whether any kind of draft is sent on to the Board of County Commissioners. And I'm going to make a few other prefatory comments, and then I'm happy to turn this over to Mr. Coffey for making some comments himself. And I'd like to say this, that zoning regulations are authorized by law. And while they're authorized by law, they are powerful tools of local government. So powerful that they need to be wielded with a soft and thoughtful hand so as not to deprive landowners of their reasonable expectations of the use of their land. Farmers and agricultural uses in particular have been carved out for protection by Kansas statute and case law. Now, we have before us a proposed use for agricultural land that either never was prime land or has been played out over time. It has increasingly less and less value to its owners. It is far from urban centers, and it sits in an area where sewers do not exist and where there is very little interest in them by existing landowners. Now, my thought is this, and this is my recommendation to the Planning Commission. Failure to pass reasonable regulations regarding industrial scale solar panel fields deprives landowners of a productive use of their land. When government deprives a person of a livelihood provided by his own land, this is government overreach on a grand scale and ought to be very, very carefully calibrated. The job of the Planning Commission is to make a recommendation to the Board of County Commissioners. I think this commission would best serve its purpose and the needs of the Board of County Commissioners by passing on a recommendation to accept reasonable and financially viable regulations that allows landowners to use their land productively. Now, a lot more can be said with regard to the particulars on this, but I will say this, that while I don't personally think solar panels are an agribusiness in the traditional sense, Kansas courts have consistently ruled that any activity tied to agriculture is beyond the reach of local land use regulations. We've experienced that here in Johnson County in the last couple of years. The county refused to give permission to an agritainment, agribusiness that the court said was inappropriate because it was in fact an agricultural use and therefore could not be regulated. So instead of having some regulation, we got zero regulation. Failure by the Board of County Commissioners to pass reasonable regulations of solar panel fields will likely result in a lawsuit by the landowners. Looking ahead, not forward to, but ahead, which, if this lawsuit is lost by the county, would result in a completely unregulated use that would mean any landowner in any location in this county could put as many solar panels as he or she desired on their property, and the county would be prohibited from any regulation. Well, I'm not a gambler personally. This is not a bet I would want to make under any circumstances. So therefore, I think it is incumbent on us to pass on to the Board of County Commissioners a recommendation that is appropriate and financially viable. And by financially viable, what I mean is that in the event that the applicant cannot make it work financially, then it's a dead letter. And you strangle by regulation what otherwise would be a use that the regulations anticipated would be made. I have no dog in this fight whatsoever. However, I am a rural landowner in rural Johnson County in the unincorporated area. And I do know that if this were my land and I was told that I couldn't use it in this way, and we much more to be said with regard to the benefits of solar power, or to its contrary, we've heard from other witnesses who suggest that there is no benefit to solar power and that in fact it's a bad idea. I'm not in agreement with that notion. But if I were told I could not use my land in a way that I wanted, that was not invasive of anyone else, non-polluting, didn't create noise, did not create problems for other people, and I was objecting to it primarily on a basis of aesthetic basis, that would be very upsetting to me as a landowner in Johnson County, and as I suspect it would be to everyone who is here. At any rate, that's so much with my prefatory comments. Well, I have allowed that to come out as the initial opinion from myself. I don't expect that everyone here is in agreement with me, and I am eager to hear other people's opinions.
Hi, this is Kelly Rass. I just have one question, just to clarify on some of your comments regarding like the lawsuit, those things. Are those your opinions? And is that speculative? It seems like a lot of your stuff, just to clarify, a lot of the comments you said were opinions and speculative.
Everything I've said tonight is an opinion.
Okay, so it's not backed up by any factual
opinion.
knowledge, opinion. Okay, great. Wanted to clarify that.
I didn't think it was unclear, but you're right. It is an opinion.
Okay.
Jim Neese. Mr. Chairman, I've got a couple of comments to your opening statement there. First of all, I wholly agree that we need to have some recommendations sent on to the county commissioners. There's no question in my mind that we need to have some set of guidelines that does go forward to them. I don't know that you can really compare this to the pumpkin patch or some of the other deals. I mean, you can, but I don't know that's kind of in the same ballpark. One of the big comments is that it's my land. I ought to be able to do with it what I want to. And I think that is partially true. It comes to a point, though. I think you've been on the zoning board for years. I've been on one for over 41 years. And I can't count the number of times that somebody wanted a dog kennel. This last month, somebody wanted a small plot of land to put a tower, very unintrusive tower. And we voted on that. And sometimes the zoning boards denies what the landowner would like to have. And the zoning board has a responsibility to look at these things, hopefully being consistent. But when it boils down to, and I'm sure you've done this, and if you haven't, I stand corrected, is that sometimes, I don't know if it's a greater good, but you have to look at a particular area in a situation and make some kind of guidelines. I asked the staff last month at our zoning board, and I've asked this the last couple of times, basically because what we're doing here is, why do you have a kennel for 10 years? Or why do you have a show-up yard for 10 years? Or why do you have towers for 10 years? Why not 40 years? That tower can be there for 50, 60 years. And there's a reason that certain timelines have been established and guidelines for property of people who would like to do something and not have any controls whatsoever. But those of us that are sitting on zoning boards have probably denied situations that a landowner would like to have. And the reason we did that was we tried to take into consideration what the landlord has, but we look at growth. We look at how it affects the environment. What 10 and 20 years goes. We did a rock quarry in our area, 10 years, rock quarry, renewed, had a big battle. Staff writes us a letter every 6 months that they're complying with the regulations. And that's a 10-year deal. And we didn't ask how long is it going to take the trust to make a profit. That's none of our business. I don't think it's our business as a zoning board. I'm talking now with my zoning board hat on. And we're going to make a recommendation to the county commissioners that is going to affect folks. And I don't know that it's our place. Randy, you asked that one time, and I respectfully kind of disagree with you. It's not our place to, how long should we have this? Let them have this show-up yard for construction out here until the guy breaks even. That's not our place as a zoning board. So the thing that bothers me about this particular situation, we are talking about one applicant. And I really don't care where it is. I don't care how fallow the ground is. I don't care whether it's spent. I know that hay ground in this county, you get $70 an acre to rent hay ground. You get $135 an acre kind of average for plowed ground. I really don't care, okay? Because we're making rules and regulation recommendations to county commissioners that could be at 127th and Moonlight Road. You know, this thing's way out in the country, but this regulation that you've got here, and I'm not saying that I'm opposed to it, but we've got our foot in a rut here talking about this one potential application. Because I personally know there's going to be another application for 3,500 acres coming around the road. And what if the guy at 127th and Moonlight, right in the western growth of Olathe and the southern growth of DeSoto, he decides he wants to put his 450 acres and stop the growth in that direction. So all I would say to my fellow members here is, let's think of this as a picture into the future, 40 years from now. If you look at the maps that they put up here, okay, before the intermogul, and look at Spring Hill and the growth there. Some of the rules or some of the regulations that are written into this, which we're going to discuss, don't just pertain to this one applicant, but it pertains to the guy that's at the Four Corners and a little bit east of Spring Hill and a little bit south of DeSoto. And that's what we have to think of. And that's where I think your statement was geared to this one applicant, and we have to think beyond that. So again, I'm not opposed to solar. And And I think we do have to send the recommendations up, but I think we have to think about what the taxes are going to be in 40 years. When you pick your future value of money in 40 years, they're talking about $25 million, nothing for 10 years. Well, the bankers, if there's any bankers in the area here, you figure out what the cost of a dollar is going to buy in 20 and 30 years. It's not going to be very much as opposed to $500,000 homes that may be out there. And not there, when I say they're not this place, but 2 miles outside of DeSoto or 2 miles outside of Olathe or Gardner or Edgerton. So anyway, I've blown enough, but this is kind of a feeling meeting here. So that's what I feel.
Yeah. And this is Kelly Ross. I'd like to echo a lot of that sentiments as well. But I'd also like to say from the standpoint that we need to remember this isn't a referendum of whether solar is good or bad. This is to discuss whether this is appropriate land use, appropriate for our county, our citizens in the future. And one of the things that keeps coming up is industry standards. Well, I have literally pulled up every single solar farm that is either in business today or going up, even the new Texas one that is huge because it's actually down by my husband's family and stuff. There's nothing in the industry that represents what they're trying to put here in Johnson County. It doesn't work. It doesn't fit. And with all due respect, a lot of your comments of your opinions, you can take those same arguments and reverse them to the other side of the landowners who feel like their land is very valuable the way it is and what they can do. So I think that's what makes it kind of difficult. But yeah, we do need to set some regulations. I agree with all that, but we really have to look at this as in context of how it fits our county. I, for one, will say there's lots of things I'd like to do on our 4 acres, but I'm not allowed to do it because it's not allowed in our county. And my neighbors would go through the roof if we wanted to have 2 little goats because they're not allowed. So that's an argument that goes both ways. But as far as like from an industry standard thing, we don't allow turkey farms, we don't allow feedlots, we don't allow hog farms. There's a lot that's not allowed. So yeah, so we just need to go through this and see and keep in mind what works for our citizens in our county for now up to 20, 30, 40 years.
Leaving an opening here.
Randy Hutchins. My thoughts are first and foremost is I want to compliment staff and this commission because I think we went through a very detailed process. Thinking about 1.5 years ago when this first came up, we didn't know anything about solar farms. And we kind of looked at one another and what do you all know? We didn't know anything. And credit to staff, they went out and found a source that would help educate us. And that was very impactful. That helped us along the way. We also grew as a commission as we heard public comments and whatnot. I think we really garnished a lot of that, both from the landowners, both from folks in the cities, city staff, as well as current staff. And so that helped prepare me, I think, for this moment. I get asked the question a lot, well, are you for or against solar farms? Well, quite frankly, it's neither. I don't have an opinion about solar one way or another. What I do have an opinion about is the landowner's rights. All right, very much to what the chairman just mentioned is no one from the city offered to make the farm payment, I'm sure, to these family members right here today when they had a drought. All right, when the prices of hogs were 15 cents a pound, the price of corn was $1.80. I'm pretty sure if you ask them, no one came from the city and said, I love the rural character you provide. Here's $20,000 to help make your farm payment. I'm pretty sure that never happened. All right. So when I hear somebody from the city now wants to limit their ability to finally, their ship came in. Their ship came in. And now we want, someone from the city wants to say, well, I like the rural character this way. And I think you should forego 50% of the profitability of your land because it's not to my liking, right? That's where I have a real issue. All right. And so, you know, if you want to earn credibility to me, all right, this land is the farmer and landowner's 401k plan. So if you want to gain integrity with me, you offer up 50% of your 401k to the city because you believe in the future growth of the city. All right. If you want to offer up 50% of your savings to the city, so be it. Then I'm all ears, right? But unless we're all ready to do that, how can we sit here as a commission and look at these landowners in the eye and say, we recognize you can get, I'll make up a number, $1,000 an acre, but you know what? We're not going to allow you to do that because you know what? We may want to put a house there someday. We may want to put a warehouse there someday, right? We don't care what you want. We care what we want. And that's where I have a lot of heartburn. All right. And the chairman's made some really good points, and there's a lot of discussion in the community. What is our role? All right. So when we start talking about that, I mean, the questions become eminent domain. So we have a city now going to dictate to the landowners what they can and can't do. That is worse than eminent domain. You know why it's worse than eminent domain? Is because when somebody declares eminent domain on a landowner, they have to pay fair market value. This is worse than eminent domain because you're declaring what they can and can't do with their land, but they don't get a single dime. Now we've got school boards and school districts that are going out and buying land, such as Gardner. They purchased 80 acres more than 15 years ago for future growth. They spent hard cash. They went to the landowner. They paid hard cash. The cities are bringing nothing to the table. What they're bringing to the table is a wish list. Oh yeah, if you ask me, I will tell you, oh, I don't want these solar farms within 3 miles. Why? Because it's self-serving. All right. So, you know, I appreciate Mr. Neese's comments, and I'll say the same thing I said in the very first meeting we had. And the question becomes is, why do I care whether it's profitable? The comment I made on the very first meeting was if we are going to do this, we need to set these companies up for success, not failure. My worst nightmare, and a lot of you all here too, is they can't make it, they go bankrupt, and now we got a field full of glass and we're trying to figure out what we're going to do with it. So we need to get realistic rules and regulations set up to where we can, not carte blanche, you can do whatever you want. It's working, as the chairman said, working with the county, working with the cities, and working with the company that's putting it in place to come up with reasonable expectations of how we can all work together. I'm pretty sure I've said more than once, and we need a win, win, win. All right. It's not all one. It's everybody working together to make this work and make it be successful. So those are my thoughts, and I go into this, and I don't, like the chairman, I don't have a dog in this hunt, but you know, I do own land myself, and I'd be extremely concerned if somebody come to me after I paid all those farm payments and I see an opportunity to finally be secure and my ability to pass that farm on to my kids, and then somebody tell me I can't do it. That's where I have a heartburn, and I'm not a lawyer, and I'll leave the legalities there, but I'm not pro solar farms. I'm not against solar farms. I'm pro the landowner and the farmer.
Kelly Ross, and I agree with, I think this, why this is difficult is because everything that you just said makes total sense. But you also have the landowners that have 10 acres and they bought that piece of property for their investment and their future, and they're afraid that their investment's going to also go down. So that's what's difficult because you can use, like, that's what I'm saying, you can use the same argument on both sides. So obviously the answer is probably somewhere in the middle. And maybe we should go through these regulations. I do believe the city has come to the table. They tend to offer big tax breaks and incentives. So they are somewhat involved. But again, there's landowners on both sides that have different opinions of how this is going to help or hurt them. And I don't want to be that person that judges that. I think what we need to do is see where it works in the middle with the whole county of what's right for the county, if that's possible.
Mike Levin, Mr. Chairman, I think at this point, if you want to do a vote, if we're going to move forward with some type of regulations, I think we can go ahead and do that. I think unless other people want to speak, I think it'd be a good time to move forward, if I might suggest.
All right. Well, I guess Mr. Levin, I think your suggestion is an excellent suggestion. This is Chris Iliff, by the way. I would say this is a vote for guidance to the staff. This is not a vote to recommend anything to the Board of County Commissioners. That will happen next month, if at all. And that is, I'll just, since I've got the microphone right now, I'll just say, all those who are in favor of creating regulations for solar facilities that, like we've been discussing now for the last 3 months, and sending it out onto the Board of County Commissioners after the public hearing next month, indicate by saying aye.
Aye.
Aye. All opposed, same sign. All right. So we can move on. There are lots of other issues that we can discuss. And again, I would invite Mr. Coffey to join in here. But the highlighted issues in the October 2021 issue or memo are with regard to the term. I think if everybody's read their materials, that the staff is recommending 20 years. The Next Era people are recommending 30 years. The maximum project area, 2,000 versus 3,000 acres. Distance from cities, 1 mile versus 3 miles or something in between. Screening and buffering, and then decommissioning and reclamation. And I don't think there's really even much disagreement there on the last issue at all. And these are the things that I think we need to give some guidance to the staff here on. And apparently, Ms. Miller, you are ready to make some comments on that. Is that right?
And I'm here to work the memo on the screen, and we'll have Darren Coffey start speaking now. If Leslie can pull him up.
Yep, I'm here. Can everyone hear me okay?
We can.
Excellent. Well, y'all sure do make my job easy, I'll tell you that. I'm Darren Coffey. I am a co-owner and principal of the Berkeley Group. We are a local government consulting firm. I am here this evening with Michael Zahner, who's our environmental programs director, and Lindsay Edwards, who is our clean energy planner. And they're just sitting in to listen while I help facilitate this conversation. I will say that, in a lot of ways, as y'all have probably figured out by now, this land use is not like any other land use that we as citizen planners and professional planners have dealt with before. But in other ways, it is just like any other land use in that if it's done properly, it can be regulated. You can mitigate the adverse impacts. Location is a huge driver. But these other parameters that we're going to be discussing this evening are also very important ways that can help to locate and operate these facilities successfully. The Planning Commission's role.
Mr. Coffey, let me stop you just for a second.
Yeah.
This is Chris Iliff. I'm the chairman.
Yes, sir.
there is an issue I would like you to address at some point, if not now, then later on in your comments. It is not addressed anywhere in the draft regulations or in any comments that have been submitted by the staff. But there is an underlying presumption by opponents of the solar facilities that the existence of these solar facilities near their property will have a deleterious effect on the value of their property. And since you're an independent consultant and an expert in the field of solar panels and that sort of thing, at some point, if you would address that issue, I would appreciate it. My own experience with regard to claims that a particular use will harm the property values of a neighboring property is that I've never seen evidence of that. And so I guess you in your with your breadth of experience might be able to address that. But at any rate, I've interrupted you and I apologize for that. But I think that since that is the underlying tenor and perhaps the strongest emotion driver with regard to this issue, I think it would be helpful if we had evidence of whether that the concern is warranted or not.
Sure, I appreciate you bringing that up. As I was saying, with any land use that the Planning Commission deals with, that zoning boards deal with, it's always private property rights versus public good. I mean, that's the whole nature of zoning, and the whole point of comprehensive planning is trying to get that balance. And I just wanted to say that in working with your staff, they have really done an excellent job taking these concepts, incorporating them into your existing regulations to see what it would look like if regulations are adopted to permit these facilities under certain conditions in certain locations at the discretion of the zoning boards and the Board of County Commissioners. And so that is where we're at. Before I get into facilitating us, you've got a 35-page draft ordinance that has a lot of detail in it. And I would just say that in my professional experience, your staff has done an excellent job pouring through those details, integrating them into your existing codes and policies, working with your legal staff. And so we've boiled this down to kind of the top 10 list. And quite frankly, there's really only 5 things that I think we might talk about back and forth before we land each one of them with a straw vote or however y'all want to do it. To answer your question that you just asked regarding property values, the cop-out answer is that I am not a real estate appraiser. I'm not a real estate professional. And I'm not qualified to answer that technically. But in my experience with any facility located anywhere in any county or any locality, I have not seen a study that shows a negative impact on property values, adjacent properties of these facilities. I rarely do I see any land use, quite frankly, if it's done correctly, if it's buffered correctly, that has a negative impact on property values for surrounding land uses. But certainly with these, you're talking about screening and buffers. You're talking about, is it being located? Are you allowing them to cluster? Are you allowing them to locate next to urban communities? Where is the balance? And that's where the rubber meets the road. And that helps to protect property values of adjacent property owners. Everybody wants their slice of the pie. Not everybody can have their slice of the pie. That's just the harsh reality of the balance between private property rights and public good. And one of the reasons that y'all's role as planning commissioners is so vitally important to Johnson County is that not because of the cities, but because of the county residents and the county's values, you get to make the policy recommendations to the Board of County Commissioners that the zoning boards and the planning staff will then use to consider applications as they come in. And I will also say real fast that we're not doing this because of one application. We're doing this because if it's possibly appropriate to permit it for one, then there will probably be others. There's one potential applicant that maybe was the catalyst for this conversation, but in drafting these regulations, we have not been thinking of just one potential applicant. We're thinking about what is the best balance, if any, for Johnson County residents and stakeholders. And so to start off with that is the term, which is being recommended by staff and has a lot of precedent. Mr. Chairman, as you mentioned, every use permit in the county historically has a term associated with it. The industry would very much like to see the term increased to 25 or 30 years if there's going to be a term at all. I think the county has made it very clear that there is going to be a term. And so the first item for the Planning Commission to discuss, and then once everyone has had a bite at the apple, I would just suggest that we take a kind of a straw poll or a voice vote like you did before, just to see whether folks think 20 years is appropriate or potentially something more or something less.
And this is Karen Miller. And just a reminder, when you do your straw poll, is that there are commissioners on Zoom and to include those in your vote. The commissioners on Zoom.
And for me being on Zoom, I wrote down that first question, should Johnson County permit utility scale solar, was a unanimous yes. Is that accurate?
According to my head count, yes. Or is there anyone on Zoom who would like to make a negative vote at this point? Well, I'll take that as a unanimous yes then, Mr. Coffey.
Okay, and I think that same type of clarity for each one of these 10 items would be awesome.
Mr. Chair, Mike Levin, I have a question for staff regarding the term, if I might.
Yes.
I don't know if you can provide this information. Historically, when a permit has been given, an initial special use permit has been given to an entity of some type, if that entity is following all of the regulations as put forth by the county, is there ever been a time where you have not renewed that permit?
Commissioner Levin, Jay Leipzig. I will make a first attempt at answering your question. I believe the answer is no, not that I'm aware of, but I'm going to ask Ms. Miller if she's aware of anything.
Karen Miller. So I cannot think of anything that has been denied after having an initial term, but I've had several discussions with legal staff, and the purpose of that term is to not only make sure that the applicant is following all of their stipulations and requirements, but also to be able to return back to that application from time to time to look how the county has grown, what the character of the neighborhood is, because that's an important part of the golden criteria. And this golden criteria is the standard that we judge conditional use permits. So that would be an important part on a long term, like a 20-year term, is to return back and do another golden review and see how the character of the neighborhood and the growth of the cities have gone.
Okay, then that would give me a follow-up question then, and I appreciate your answer. So no matter what the entity is on a large scale type of project, so if they are following the regulations as set down by the initial special use, you're telling me that if the land area use around it changed, then potentially that would not be renewed, even though they're following?
That would be definitely a point of discussion. And I know that the zoning board and the Board of County Commissioners would contemplate that very carefully, to either decision, but that would be a possibility.
Thank you.
I'm going to,
Mr. Chairman,
yes, Mr. Neese.
Jim Neese. I think that was really a good question, because on a zoning board, we get some requests for 5 years or 10 years. So there, you've got a shorter term. So let's just say that I'll use this a dog kennel, boarding, okay? And it's where I live, half a mile outside of Olathe city limits. And it's getting closer to where I live. And I have a 5 or 10 year recommended by staff, zoning boards approve it. And in 5 or 10 years, that whole thing can change. And as a short-term, conditional use permit, you can look at those types of things and change them. But when you're talking about 20 years, okay, at 10 years is about the longest, and most conditional use pits are, is that can be a major change as the map showed us. So that's where this, I think that term, and I don't disagree with the 20 years. I don't like the 30 years, but that's where this 20 years is a big deal compared to other terms. Because in 20 years, this area that we're talking about in an unincorporated area, not just where this one is, it's going to change a bunch.
Mr. Levin, I do think that's an excellent question, and I'm going to inject here my experience of 30 years on a zoning board and another 25 or 30 years on this planning commission as well. And we've been often asked, when I was in the Aubrey Township Zoning Board, it's now part of the Southeastern Consolidated Zoning Board, for 30-year permits. And usually where that is asked for, it is a result of a large capital investment into a particular item, say a cell tower, or certain kinds of structures, where financing is not available to the landowner unless they have a conditional use permit that allows them a minimum of 30 years. So it is not uncommon. Now, the great thing about conditional use permits is that if the landowner fails to comply with the terms of the conditional use permit, the county is able to go in and make them comply, or they can get orders from courts causing them to cease and desist from actions that are not in compliance with the conditional use permit. It isn't done often. It's not easy, but in a project of the kind that we're talking about here, which is so large, it involves so much money and so much land. If the applicant or the person, we'll just say NextEra, since they're the obvious party involved here, if NextEra failed to comply with every single element of the conditional use permit, they risk having the conditional use permit rejected and pulled. That's why it's called a conditional use permit. It's not an absolute. It's not like having fee simple title to a piece of property where you can build any house you like. You must comply with the terms, or else you have the possibility of having it rejected. And that's why, under rare but occasional circumstances, my zoning board has recommended, my old zoning board has recommended 30 years in order to allow the applicant to get financing. And they understood that there is a caveat with this, and that is you jeopardize the entire project if you fail to comply with the terms of the conditional use permit.
Jim Neese, Mr. Chairman, what about the guy that just wants to do 240 acres right in the middle of right a mile and a half? I think we're up to a mile and a half in the city. So what happens if a guy wants, a quarter section or half a quarter section right in the major way, and he's not worried about financing because of the size of it? We're not talking about these folks here. And 30 years from now, he meets all the rules and regulations, but there's no way to look at this and determine, and there's something like this, there's no county commission is going to have the fortitude to turn this down after 20 years if it's still functional and doing good. What about the guy that's got the smaller deal? And it's a mile and a half from City Hall. I mean, we keep thinking this big deal here, but they're not all going to be big deals.
Yeah. Well, I'm not exactly sure I understand your question, Mr. Neese, and I'm not sure I'm qualified to answer it, even if I did. But let me say this. I spent a number of hours last week driving the area out in the southwestern part of the county and also asking a few questions about future land use and that sort of thing. This is ground that is a long way from anywhere at this point. The closest structure in some cases is, well, the ground is not sewered and largely unsewerable. It looks to me like this is ground that is going to be agricultural use or some other use for the next 50 years. I could be wrong about that, but I would like to hear testimony with regard to what kind of future land use would bring, the city that close to this ground.
Jim Neese, we're not writing regulations for this one deal, sir. We're writing regulations for the entire unincorporated area in the county.
Well,
And are you going to write in the regulations? Let's write in regulations. It's never going to be, it can never be sewered.
well,
It can never be developed. And let's write that in there.
well, Mr. Neese, the third item on our list is distance from cities. So yes, you're right. We're writing a regulation that is for everybody that is here. But if we have a 1 mile limit from cities, then that's for everybody, including the guy with 240 acres who's closer in. And it can't happen if he's within the limit that is set by the regulations.
Mr. Chairman, if I could also just add, once we get through this exercise and we've got a set of recommendations that go to the Board of County Commissioners, and once the Board of County Commissioners adopts those and they're on the books, and then zoning boards start considering these applications, the Board of County Commissioners starts considering these applications, it is highly likely that you're going to want to amend these policies and regulations to adjust them based on, what you've seen come through, what's worked well, what hasn't worked well. And even if that doesn't happen, if an application comes in and they're following all the recommended rules and regulations, but the location is just not great in the opinion of the zoning board, citizens, the Board of County Commissioners, it's still a discretionary action. And it just might not be the right project for the right place, even though the applicant has followed everything that we end up putting together as part of this project. So don't lose sight that it's a discretionary process, even once these things are put into place. What we're trying to do here is establish some policies and regulations where there aren't any right now, because it's such a unique land use. We haven't seen it before.
Yep. Thank you, Mr. Coffey. And I agree, Mr. Neese, you and I would agree as zoning board members, that is one of the great things about sitting on the zoning board is we have the capacity to say no to a project that's just not right. Yeah. So.
Randy Hutchins, going back to my earlier comment about when, we've already have instances where the landowners and the company at question is doing 25-year contracts, as my understanding. My recommendation, we're dealing with a three-legged stool here. I don't want to be at odds, with these agreements. It only makes sense we move forward together and do these in 25-year increments as they were already agreed upon with the landowner and the company at large.
Kelly Rass, I have a question. What is the standard length of term for CUP for like a cell tower? 10 years?
Sean Penley, planning staff. The standard term for a CUP for a new communications tower is 10 years. That's typical for most conditional use permits. However, certain uses, there is a provision that longer or shorter terms may be approved by the board due to given site circumstances. But the standard term for most of those uses is 10 years.
And has that situation come up where you've given longer terms?
There have been situations where some uses have been given longer terms, and one example is communications towers. Those have been approved for up to 20 or 25 years for certain circumstances where, for whatever reason, maybe there was a longer term for that particular use on that site. And as I think Ms. Miller noted, one of the things we look at in terms of these terms and the uses are and the ability to come back and review this with the golden criteria. Any one of these land use impacts, we look at the individual site, what is happening around it, the future growth of that area. We need to look at that, and that does change over time. And so that's why we typically recommend the 20-year term for a use such as this. It's a large scale use, which a large capital impact. You want to look at the surrounding area, future growth. And so at that period, 20 years is what we would recommend for a prudent time.
Yes, thank you. That makes total sense. And so, and one of the things that, even from looking at the other side, that, I mean, obviously we're trying to look at a crystal ball, looking 20 years into the future. But I mean, if the companies, these solar farm companies believe so much in their project that it's going to be well received, it's going to be loved, whatever. I mean, they may just have to take a little bit of their own risk of that extra 10 years or something, but both sides can put a little skin in the game of, is this going to work and what's this going to look like? I mean, one side doesn't have to give 100%. We need to do what's, works out, but that's a way to think of it as well. As, they're saying it's great. Everybody loves it. It's perfect. So they should bank on their own opinions of it too. Anyway, thank you.
So moving along with regard to this issue of project term, are there other comments by members of the commission with regard to their thoughts or opinions on the term which is being recommended here by our staff of 20 years or the term that is being suggested by Next Era of 30 years?
Mark Huggins. We have the report from, I believe, October 11th, where staff is recommending a 20-year term. I assume the consultant was involved in that recommendation.
This is Karen Miller. And we discussed the idea of the term with the consultant, but we also discussed it with our legal department and looked at it within the context of our own regulations. And it's the county philosophy that we need to have terms on our conditional use permits for that very idea of the golden criteria and coming back and looking at it. There are other counties who have done other things with the terms, but those are counties who don't have the large urban area that we have. We're fairly unique in the counties that I know of that, like, for instance, maybe don't have terms or run for the life of the facility, are not at all urban like we are. And their growth is nothing like ours.
Let me make sure I understand. You've got evidence of other counties that have had longer terms for these facilities?
Yes.
How
And
long?
I think Mr. Coffey could speak to that a little bit better than I can, but yes.
Yeah, Johnson County is somewhat unique in how they do this because of, just the culture of how the policies and regulations have evolved. And there's nothing wrong with that. Every place is unique. I am generally not used to seeing any terms with a conditional use permit. It runs with the land. It runs for the life of the facility. That's just simply not how it's done in Johnson County. And I think that needs to be respected by the industry and by every applicant. I think in my discussions and trying to understand this issue better at the local level, staff has made the recommendation of 20 years. I think there's some comfort level that if it needs to be 25. That could be acceptable, but there's a lot less of a comfort level if that needle moves to 30.
Mr. Chairman, it's Jay Leipzig. If I can just say a couple words about that too, in regard to the magic number of 20, where that came from staff's perspective. We chose 20 years because that is our planning period of our comprehensive plan. And I think that was stated earlier, but 20 years is kind of a typical amount of time for comprehensive planning and kind of reviewing it. Historically, in Johnson County, 20 years has been our threshold in terms of how forward we're planning. However, as Mr. Coffey just said, whether it extended further, 25 years, what Mr. Hutchins had just mentioned with the, typical lease. But there again, what we really need to focus on is the land use, aside from the business practices. So that's where staff came up with the notion of 20 years.
And this is Karen Miller. And the reason for that 20 years is that's what we're comfortable planning into the future. Think of the city of Overland Park in 1960 to 1980. That trying to plan much further than that would be pretty difficult. So because of the nature of our growth, we think the planning period of 20 years is pretty significant.
Mark Huggins again. I also would like to tie this in with the maximum project area. Some of the arguments I hear is it's a huge investment, which requires a longer term. But we haven't really gotten to the point where we've come to terms with this project area size, and I think they're directly related. And I would like to bring that into this discussion. And I wish I knew more about these things, but what I'm hearing is that a 4,000 acre facility is unheard of. That most facilities are much smaller, even smaller than the 2,000 acres. And if staff has some data on that, or the consultant has some data on that, I'd really like to hear that. Thank you.
Yeah, in my experience, especially over the last several years, that is not accurate. These facilities are tending to get larger and larger. I think that the only reason maximum project area would have anything to do with the term is because of the industry's ability to finance a very, very large project. But unless you're planning on increasing the 2,000 acres significantly, I think probably the 20-year term with the recommended limit is a pretty reasonable balance. There is no magic maximum project area. There is a project being proposed near me in Virginia right now that will take up 21,000 acres. The project actually will only, quote unquote, cover 6,000 to 7,000 acres, but it's 7.5% of the total land area of the county. So it's a huge project. There's another one that's being constructed in another county in Virginia that's 6,500 acres. I think that's 3,500 under panel. So these projects are getting larger and larger and larger. I would say the smallest maximum project area that I've seen with one of our clients was 300 acres. And that is definitely on the small side these days. It used to be, 20, 30 years ago in North Carolina in particular, you'd have 5, 10, 20, 15 acre projects. 100 acres was big. That is just not the case anymore. The most lenient of any of our clients currently, and there is 1, 2 of them that are considering putting this into place, is 5,000 acres. And that is definitely a large facility. And so just to remind the Planning Commission, we started this conversation just for purposes of having a number at 1,000 acres. And as the process has evolved, I think staff talked about it, looked at some other facilities in other states. other facilities nearby your location. And they felt like 2,000 would probably give more flexibility and be more appropriate. And of course, that's just a maximum. Also, there is a little bit of flexibility in that a project does not have to be completely contiguous. There can be some outlying parcels as long as they're not too far away. I think it's within a half a mile. But the total project area would be capped at 3.1 square miles to allow for some outliers and some project design flexibility. So to me, there really isn't a correlation, not a strong one, not with the size we're talking about currently. And I think 20 years, from everything that I've heard and seen and read and talked with your staff, that seems reasonable within the context of Johnson County's history and regulations.
I've got Jim Neese, I got a question, Mr. Coffey. I looked on the applicant's website. Are you familiar with the operations that they've got in process right now? They're larger operations.
I am familiar with Next Era as a company, yes.
Okay. Are you familiar with the Liberty Grand?
Not specifically, no.
Well, they list about 5 or 6 things of large projects. I think I read this right, that are in process. And I don't deny that they're probably going larger. Earlier I gave a list to the county because I went over the ones in Florida, Cleveland, and everything else. And a lot of them were 75, 80 acres. Like in Florida, they have many, many applications down there. A lot of them are under 100 acres. So I looked up the ones that they touted now on their website: Liberty Grand, Appleseed Solar, Dodge Flat, Nevada, Neptune, and South Landry. And these are all, probably 100 megawatts, pretty large facilities. Almost every one of these are Grand Liberty's 15 miles from Houston. Nearest town's 5 miles, 13,000 people. Appleseed's 40 miles from Indianapolis, 4.5 miles from Logan Sport, which is a town about 4.5, 5 miles away. Dodge Flat, Nevada is 20 miles from Reno, 3.5, and that's 469,000 people. 4 miles from Fernley, which is 21,000 people. Neptune, which I think the folks here visited, is 9 miles from Pueblo. It's 170,000 people. 35 miles from Colorado Springs, 20 miles from Fort Carson. South Landry, Baton Rouge, 40 miles. Port Pierre, 2 miles.
Mr. Neese, I don't mean to interrupt, but can you
Okay, I'm
summarize
just,
for us here, please?
I'm making a point here, sir.
Yeah, please do.
That my point is that the larger ones that we're looking at are not similar to our county, which the 2,000, I think the staff's going to take up like 4% of our unincorporated area. My point is that if you talk about large facilities, and I'm in the right spot, it's not a problem. So to argue about one that's in Virginia or someplace else is 5,000 or 6,000 acres, these don't compare to us here.
I absolutely agree.
Talking about size now, so I guess we went to size, and that's my main concern is the size. I'm not worried about the term. So anyway.
Yeah, absolutely agree with that. And that's why this conversation is so important, because this is the Planning Commission's opportunity to put, for you as the citizen planners of Johnson County to say, this is what my opinion for what is appropriate for each of these big policy areas for the character of our community. And that's what makes it so unique. So we do this similar process, state, but the products end up turning out to be fairly significantly different because every community is different and they should be different. So, Mr. Chairman, if I could suggest back to the term, is there a consensus on 20 years? Are there any strong feelings it should be more or less?
Well, that's a good question, Mr. Coffey. I don't know the answer to that. What I'd like to do is give an opportunity for anyone else on the commission to express any opinions that they have, and then we'll take a straw poll again on that.
Mr. Chairman, Randy Downing. Quite frankly, 20 years just seems like a number pulled out of the air. I mean, I don't know where 20 years would come from. It's any better or worse than 10 years or 30 years. So I think we should look at projects based on their cost and what it's going to take to put it together and make it successful and go from there. I mean, if 25 years is what it's going to take for a payout, as a business person, you know, I've helped build buildings for our company all over the place. And when you go in and talk of them, you have to set standards based on what the payout's going to be. So, and I just think that as technology improves and as we get more into these things, who knows what the next one's going to be besides a solar farm. I think we have to be open to be flexible and to be able to provide things that are going to help people move forward in the community. I mean, I think solar is going to be important. I think it's going to happen. So I just think we have to look to see what really is going to happen to make it work.
Well, and I would add to that, Randy, that just because there's a 30-year maximum doesn't mean that the zoning board has to agree with that or provide that. The zoning board still has the discretion.
Kelly Rass, I differ from that. I actually think the planning committee the staff has done an amazing job of kind of backing up their rationale of how they came up with 20 years. You know, I just want to give them credit because they have answered that question multiple times of how they've come up with the 20 years. And it makes sense for our county. And once again, I keep trying to bring myself back to, we need to be looking at this from the perspective of our county, not whether we make a company profitable. It's what's best for our county, not another company. We have to stick to that because I'm really worried about the precedents. We got to remember, we open this door and there could be several coming, you know, down the pipeline. And it's like, you know, how do you stop them? And where is the precedence? And then at some point, someone's going to say, well, we're exactly like these people over here. Why can't we get, you know, I mean, we do have to think about, this is about our county and our residents, not the profitability of another company or any company. And we have to stay from that focus or else we can go back and forth all night. And the planners have done an amazing job sticking to what makes sense based on our county to kind of use as guidelines. And we need to discuss it from that standpoint. But it is from the county perspective and our citizens and what's best for our citizens as a whole. And yes, there's going to be some that agree, some disagree, but as a whole and what's best for our community going forward, not a private company. Nothing against private companies. I'm a capitalist, but this is our county.
We've been at this an hour and 25 minutes. Can we wind up the conversation, then maybe take a vote when we come back from a break?
Roger Mason, would you like me to hold my question? And
No, please go.
Picking up on a couple of things that I've heard other commissioners say, I think what Randy just spoke of and the other Randy spoke of a while ago tie together. It's got to be a win-win-win situation here. I think we have to build in flexibility where we can in these ordinances. It doesn't harm us to have a maximum 30 years, knowing that each planning commission will hear that the Southwest will hear different than the Southeast, and they will set the time regulation for that project based on that project. And that also needs to have some flexibility in the financing because, as Randy next to me said, financing changes over time. Sometimes you can get it to pay out on a 20-year term, sometimes a 30-year term. So I think flexibility is important. As the consultant said, we changed our size from 1,000 to 2,000 just in this little time we've been talking. This whole industry is going to change, and I think we need to keep flexibility in there. I believe myself, an opinion, is that we will see hybrid farms. I think we'll see wind and solar mixed together on the same piece of ground. We're going to have to get more efficient at how we get electricity to our people. I think that might be a flexibility you want to stick in there somewhere.
Anything else to be said? Why don't we take a 5-minute break? I'm going to make a motion for our consideration. And it is sort of a compromise. And that is, and again, this is for staff's consideration for putting in the final draft that will go to the Board of County Commissioners. And what goes to the Board of County Commissioners may very well have options for the BOCC to consider. They're the ones that earn the big bucks and have to make the hard decisions. We, on the other hand, are just a recommending body. And my motion is going to be this, that the project term be for 25 years. And so I would, at this point, ask that for all those who would be in favor of a project term of 25 years, we're going to take a roll call. The last vote was a little uncertain because of the fact that we have one member who can't seem to get her sound to work. So Lisa, Leslie, if you would run a roll call, we'll hear and just say yay or nay. Yay, you're for it. Nay, you're opposed.
All right, Mark Huggins,
Yes.
Chris Iliff,
Yes.
George Lund,
Yes.
Roger Mason,
Yes.
Randy Hutchins,
Yes.
Jim Neese, Dave Johns,
No.
Lindsay Grisay. Now, we still show her as on, but I'm not sure if she's unable to speak.
Just listed as abstention at this point.
Yes, sir. Kelly Rast,
No.
Michael Levin,
No.
and Randall Downing.
Yes.
Okay. I was listening but not making notes.
Excuse me, 6 yeses, or 7 yeses and 3 nos, 1 absent.
All right. All right.
Mr. Chairman,
Yes.
Mark Huggins. Is that a sufficient vote, or would it be worth asking the question, would 20 years be more agreeable?
If you want to make that motion, Mr. Huggins, I'm not opposed to that.
I would make a motion that we consider a 20-year term option.
This is Mike
I
Levin. I'd
saw that.
second that.
Okay. So again, if you would, Ms. Davis, do a roll call.
All right, so Mr. Huggins said yes to 20.
Yes.
Chris Iliff,
No.
George Lund,
No.
Roger Mason,
No.
Randy Hutchins,
No.
Jim Neese, Dave Johns,
Yes.
Kelly Rast,
Yes.
Michael Levin,
Yes.
and Randall Downing.
No.
All right, that is 5 yeses and 4 nos.
All right, we'll, this is again, this is for guidance for staff. And so you were asking for that from us, and that gives you about as much guidance as we can give you, I think, on this issue. All right. The next item is maximum project area. And I think all of us who are familiar with the materials that have been prepared by staff and by responses from the Next Era know that the big divide is between 2,000 acres and 3,000 acres. I'm certainly open to discussion on this point at this point.
Mr. Chairman, before the commissioners begin to weigh in, I just wanted to say that again, with these facilities, one of the main drivers is location. And so with regard to location, if you can't see it, you're not going to hear these things. They're very quiet. You're not going to smell them. But if you can't see them, then, you know, it's hard to argue that they have a major impact. And so with regard to maximum size and a lot of the other categories we're going to discuss, just keep that in the back of your mind in terms of scale, massing, which means clustering or not clustering, things of that nature. The bigger they are, the harder they are to screen, the more likely it is you'll see them. The issue there is it can change the character of the landscape. If you can see them everywhere, you know, that begins to change the character of the landscape. But if you can't see them, if they're located appropriately, screened appropriately, et cetera, then that's a whole different ballgame. And so that's a major consideration for most of the other 9 of these that we're going to be talking about. And maybe that'll help.
This is Kelly Raston, someone who has spent a lot of time out in that area with different landowners and on my own. I would agree with what Mr. Coffey just said, but why I have a hard time with the land that we're looking at is it is exactly that. It's rolling hills. There's a lot of high and lows, and there's really no way to screen it, you know, screen where they are going just because of the different heights involved. And the character of the land is very different than the character of the land that these are going up in all other places that are flat. So I'd like to make a motion that we limit the project area to 2,000 acres. And
Mr. Chairman, I think we need more comments from the commissioners before we take on such a motion.
Sure. You know, my, as I drove through there, and I have looked at a lot of pictures of different kinds of solar utility plants, ones that are out in the desert where there's no screening at all. They're just in the desert. And then ones that are in well-wooded, well-watered, hilly areas such as we have here in northeastern Kansas. And even when using our type of land as an example, when you see them, and I've driven by a number of them as well, I guess the question is, what's the problem? You know, I don't consider them ugly, aesthetically unpleasing. You know, we have perhaps the most aesthetically unpleasing site that is ubiquitous in everywhere in the United States, and certainly Johnson County is no exception, are telephone poles. They're along every street in the county. And if you stop and just sit back and look at them, they're kind of hideous. But why do we not object to them? Well, we don't object to them because they're absolutely essential for life as we know it. And so we, in our own minds, have accepted what is unaesthetic. I can't even say the same is true with regard to the solar panels. I don't find them objectionable. I think if I lived, if the field behind my house were to be fully filled with solar panels, I would probably want plantings to divide me from them. So I wouldn't see them 365 days a year. But for just driving by them, this is very rural area. And so we're talking about offending the sensibilities of people who drive down a gravel road. I don't find them to be a problem aesthetically.
I'm Kelly Rast. I don't think this is just truly about aesthetics and whether one person, and I've heard that argument a lot, and I go back and forth because for every person that says they don't mind looking at it, you're going to find someone who says they do mind looking at it. But there's far more to this. We don't even know, the land is going to be used up. We don't even know, for the most part, that this energy is going to come to Johnson County. If you read Senator Thompson's letter, he had many many points of why this was detrimental to Johnson County. So I just want to broaden the fact that I don't think anybody is just specifically talking about aesthetics. There's far more other things on the table here in a broader context when we're talking about each of these points.
Randy Hutchins. I think we're heading down a dangerous path here. I think we're on a very slippery slope. When have we ever limited industry growth in Johnson County? When have we took up as a commission how far the intermodal could go? When have we ever put a cap on North Point? So here we are today talking about we're going to cap the landowners and the farmers and what they can and can't do. So I think that if we start going down this path, then I think it ought to be an agenda item on everything that we take up is what is going to be a cap. So I just don't think it's appropriate. Certainly from the unincorporated area, we certainly have opinions, but we're not offered the opportunity to provide anything, our opinion, to city councils. But yet it always seems like the cities and the city councils get away on what we do in the unincorporated area. So again, if we want to go down this path, that's fine, but just understand the can of worms we're opening here.
It occurs to me that Johnson County residents are huge consumers of electricity, and we don't really care much where it comes from. But we don't make it here in Johnson County. We export it to our rural neighbors. So there's a coal-fired plant down in Lacine, Kansas that produces a lot of the electricity that I consume at my house. I don't have to breathe that air because it's 40 miles away from my home. And the low sulfur coal that feeds that plant comes through the railroad tracks near my house every day. And I'm happy to see them come and go, but I don't necessarily want them. Here we're talking about something that doesn't pollute, it doesn't make noise, it generates electricity, and we're arguing about whether it's going to be confined to Johnson County. Oh, I think that's ridiculous.
Kelly Ross, I don't think we're arguing about any of this. We let our planners have put tons of hours into coming up with what they think are the standards. And we're not limiting, or we're not saying that something can't be done or the slippery slope. We're trying to come up with a certain standards and guidelines, thinking about how this whole thing is going to affect the county, but then also even more into the future, and just come up with certain guidelines. They've spent lots of hours. We've listened to a consultant. They've come up with criteria that they've based it on factual information and other things. So I don't think anyway, I think we should respect what also the planners have put forth in front of us that we've looked at, and respect their rationale of how they've come up with these numbers as well.
Well, I mean, I heard Mr. Coffey say that 2,000 was pretty much an arbitrary number. And it would depend on how it looks, what the circumstances are, where they're placed, where they're located, and that sort of thing.
You did not hear me say arbitrary. I did not say the word arbitrary.
I stand corrected.
The fact that we're having this discussion, in my opinion, makes it not arbitrary. It's what fits the character of Johnson County, the most urbanized county in the state that has significant competing land uses. Where were you 20 years ago versus where are you going to be 20 years from now? And every community wrestles with that. But boy, let me tell you, you're front and center on that land use discussion, and y'all know it. And that's what shapes this.
Mr. Chairman, Jim Neese, I think Mr. Mason had made a good point, is whether we do this at 1,000 acres, whether we do it at 2,000 acres, when it goes in front of the zoning board, they can make exceptions to that. So this is a guideline. It is a guideline. So having said that, I mean, 1 week it was 1,000 acres when I talked to Jay in his office, and 10 days later it was 2,000 acres. So having said that, what's wrong with 1,000 acres or 2,000 acres, because if it's going to be more than that, the zoning board is going to make a recommendation to county commissioners, and they're going to decide whether it's going to be 1,000 acres, 2,000 acres, or 4,000 acres. So,
You're exactly right, Mr. Neese. We're recommending only.
yeah,
know.
so if staff says, it's the same, you can back up with the thing that we just went with the 20 to 25 years. I mean, I think it ought to be less than, I think it ought to be less than 1,000 acres and then have exceptions to that. But anyway, so what we're recommending on here, whether it be 1,000 or 2,000 acres, ain't gonna make any difference 10 years from now when they want to put another one and there's only 500 acres in the county unincorporated areas left. So.
This is Karen Miller, and I'd just like to make a point, just Jim, so you're not surprised. There is no waiver attached to the maximum project area at this time as drafted. So that would be the maximum area that it could be. There's no waiver. So if you vote for 2,000 acres, there's no waiver to go to 3,000.
But okay, this is Mike Levin. I apologize. So what you're telling me then is if whatever amount we agree on or we vote on and is written into it, that the BOCC cannot adjust it?
There's no waiver on this maximum project area. And
I think what Mr. Levin is asking is whether what we recommend is binding on the Board of County Commissioners, and it is not. The Board of County Commissioners makes its own decision. But if the Board of County Commissioners sets 2,000 as the maximum size, that would be the maximum size, and zoning boards would not have the ability to go above that.
Yeah, I understand. Thank you. I just wanted to make sure.
They could make it smaller, but they couldn't make it larger.
Okay. Thank you.
And that, Jim Neeson, before we quit tonight, if we can get it done, I would like for you to go over the waivers at some point in time. And I'm not sure I know what all the waivers are, but not right now, but because if you have waivers, then I'm not sure that you have anything in concrete.
There is a motion on the floor. It hasn't been seconded, but there is a motion. What's
Dave
that?
Johns, I will second that motion.
Okay. And Ms. Rash, would you repeat the motion just for the sake of everybody's memories?
Kelly Rast, I make a motion that we vote that the maximum project area is 2,000 acres and does not exceed that, and no waiver.
Further discussion before we vote?
Yes, I'd like to make a few comments. This is Mark Huggins. I think property owners' rights are imperative. I'm not very inclined to tell people what they can do with their property as long as they don't harm other people's property. I don't think we've got proof that this kind of use harms neighbors. I'm concerned about getting into a philosophy, a size where we feel we're required to allow whatever future applicant comes in to do things so it's financially. I've heard a lot of comments here tonight about that we need to make sure the regulations allow for certain criterias so that they can make money. I don't see that as my concern at all. I think that's the applicant's concern or whoever the future applicant is. When I drive through this area, it's hard to imagine being able to see more than about 160 acres at a time. So I'm not sure how relevant 2,000 or 3,000 acres is because there's no way to see that much at any given time. When I go along County Line Road right there at about 143rd Street, you probably see a little over a half mile, but I can't imagine another spot where you can. So, impact of 2,000 or 3,000 acres as far as the environment goes, I don't think that's very relevant. One concern I've got with this item 2 from the October 11th is the allowing the half-mile separation in the facility, still being considered part of a single facility. I haven't heard any discussion about that, but it seems like if you take 3.5 square miles and you put a half mile between your areas where these are, you could end up with 12 square miles very easily. I'm not sure if anybody's following me on that, but if you've got a half mile of solar panels, a half mile not solar panels, half mile solar panels, and continue on down the road, you could cover most of the western end of the county. So I'd like to make the point that I'm concerned about that, allowing the half mile of separation. I'd like to.
This is Karen Miller, and I'd just like to point out that we did think about that idea of with the half mile that the solar facility could spread out from like border to border, from Edgerton to DeSoto. And so we decided that there needs to be some kind of limit on how much you can spread. So we came up with a kind of a measure of how much the facility spreads. We call it project extent. So, if you think of, taking that 2,000 acres and allowing it to spread, we put a cap as drafted at 4 square miles is how much it could spread. But that's been something under discussion with the industry also, is that appropriate, adequate, whatever. But just to address your concern, we have done that in the regs. It's
Karen, Jim Neese, Karen, okay, let's say that, let's say that it's, this application comes in and it's down in that part of that you can't see very far. And the next one comes up, west of Olathe there, 1.5 miles. And it's a different applicant. Okay, are they restricted if it's the same applicant or different applicant? So in other words, we've got so much unincorporated area that's not right now. And
so are you asking about the distance between the solar?
yeah, I'm talking about the expansion of 2,000 and 2,000, and then you go up 2 miles and you have another 2,000, another 2,000.
You're asking if ownership matters?
Yeah.
No, it's the solar facility. You have a solar facility, and a solar facility cannot be within 2 miles of another solar facility. And it doesn't matter if it's owned by the same company or not.
Okay.
As drafted.
My thought is that the size of the solar facility is probably something best decided by the zoning board. They're the ones that live the closest to it. They have the neighbors who are impacted by it. And saying 2,000 to me, and since I put the words into Mr. Coffey's mouth, and I apologize for that, I will say it for myself, just strikes me as an arbitrary figure. And that it ought to be the zoning board that makes a recommendation with regard to the size of a particular project, and not necessarily one that has a specific or absolute limit on it. I anticipate that when this comes in before a zoning board, that there's going to be aerial photographs, there will be pictures, there will be proposed sight lines and that sort of thing that make it possible for the zoning board to say, no, that's too much impact, or at least neighbors to say to the zoning board, that's too much impact. What they may find is that because of sight lines and hedgerows and forested properties and hills and dales and swales that make up that beautiful land out there, that this has almost no impact on other people. And therefore we would say, why did we limit it to 2,000?
Kelly Ross, well, I'm under the standing that we're the planning commission, so we're supposed to be setting these guidelines, and then the zoning board looks to that. And yes, they can make guidelines by that, but we're looking at what we feel is best for the community over the term of 20 years or whatever, kind of like what the staff has been putting together and working at. So that's why we are trying to come up with this guideline so others can look to it and not leave it open-ended for them to kind of figure out. Because we are the planning commission of the whole county. And so I made a motion and it was second. Do we want to take a vote?
Sure. Unless there's anyone else wants to make a comment. Hearing nobody else wanting to make a comment, Leslie, if you would run down the line.
So just to be clear, we're voting whether we're saying yes for 2,000 or we're saying no because we want a number other than 2,000. Is that correct?
I think that's correct.
Okay, thank you.
Roger Mason, or that we want a waiver.
Well, there's no waiver on as far as how the planners.
Said no waiver.
Yeah, I kind of did.
Okay.
I agree, no waiver. Yes, no, I agree. I stand behind it.
All right. Yes.
All right. Michael Levin,
Yes.
Mark Huggins,
No.
Chris Iloff,
No.
George Lund,
Yes.
Roger Mason,
No.
Randy Hutchins,
No.
Jim Neese, and Dave Johns said yes.
Yes.
Kelly Rath also,
Yes.
and Randall Downing.
No.
All right. So that's 5 and 5.
Okay. Well, I hope that's not the best guidance we can give you, but it appears to be where we are. Yeah. All right. Moving on to the next item on the key issues, which is distance from cities. And again, we've heard 1 mile, 1.5 miles. City of Edgerton wants 3 miles, which basically excludes any projects within what they consider to be their sphere of influence. So I would just open this up for discussion.
Mr. Chairman, did we skip 3, which is distance from one another, utility scale solar facilities distance from one another?
I'm looking at
This is
the
Karen.
October 2021.
This is Karen
memo.
Miller, and I took the memo from last time where we talked about a wide array of things, and I highlighted the main issues. So yeah, we did skip distance from solar facilities, but that was intentional.
Okay.
Okay, all right. Just wanted to make sure I wasn't missing something.
Randy Hutchins. As I look with this and we've had multiple meetings regarding this at Farm Bureau. We brought in consultants as well. And what I can tell you is there are some of our members that are considering this, and they're spread throughout the area. Some of them are a 1/2 mile from city limits. Some of them are 4 miles from the city limits. So with that being said, some of my members are looking at what land makes the most sense and putting solar farms on. So some of the farmers are looking at, I've got a less productive farm that sits, it's a certain soil type that doesn't produce as well. And, for row crops, perhaps that is an 80 acres or a 160 or a quarter that would be good for that. And then I've got another member that's a half mile away from that individual that's considering it for his family. He looks at it that, hey, this is an opportunity to keep the farm in the family, for me to ultimately turn that over to my son. And it'll be economically viable for them. So, putting my Johnson County Farm Bureau president hat on, it's very hard for me to pick winners and losers. And essentially that's what we're doing when we start putting limitations in terms of how far away from the cities, how far away from other facilities. To me, I think this is naturally going to play itself out if we let it. I think if we put too many restrictions on, such as cap the number of acres, cap the size, cap the distance from the cities, I just feel like we're handcuffing a lot of the good opportunities we have. Because quite frankly, some of the ground that they're looking at, it's a mile from the city, half mile, I guess I should say, because there's a park there. And so it would be a half mile from what's being considered a city. Probably some of the prime ground for solar site. I spoke with a couple city council members in different cities. What it boils down to is what their concern is, they don't want their city landlocked. And I get that. I also understand that there has been some economic expenditures made in terminating roads, sewers, water lines, two edges of property that currently aren't within the city limits, but I recognize there's a capital investment. We don't want to strain that capital investment. So there's got to be a balance, right? I don't know, arbitrarily making a number makes sense, but there is a solution there, but I just don't think that just arbitrarily grabbing numbers and throwing them there is going to meet the needs, right? I know it's not going to meet the needs of the many landowners and farmers that are currently looking at it. And I just wish that we wouldn't try to put such stringent limitations around it. Let it play out. Let capitalism do its thing, right? It's going to make sense for some. It's not going to make sense for others.
Jimmy, Randy, let me ask you a question. When we sit on the zoning board and it's within a certain distance of a city, we ask the city to give an opinion of what they think of the project. And I think we do that is because we're potentially marginalizing what they can or can't do. And I guess, I agree with you 100%, but I guess in a situation like this is, you're almost, we're given an opinion, and it's not going to canalize your zoning board or our zoning board for having that 80 acres or 100 acres, within that area.
Well, I'd say through our experience, if we go outside the rules and regulations, our experience, when we send that back to the Board of County Commissioners, guess what happens? They send it back and say, try again. So what we do here today, most likely is going to be adopted by the Board of County Commissioners. Why else would they appoint us to this position? So what we do here this evening, in my mind, is going to drive what transpires over the next 20 years. And Jim, we want everybody's input. Everybody's input's valuable, right? But at the same time, I'm going to say it again. When do we have an opportunity to get elected as city council members and be in an unincorporated area? We don't. We don't have a say. All right. But yet we have people appointed to this commission from the city that's going to dictate what happens in the unincorporated area. That's my heartburn. I think everybody's opinion is important and I want to hear it. But at the same time, I don't believe it's fair that it isn't reciprocated both ways.
Well,
Um,
I live in an unincorporated area and we can have different views about what happens in our incorporated areas. It's not a city and country. I mean,
a question I've got for you, Ms. Miller, or Mr. Leipzig. In the county's comprehensive plan, what does the comprehensive plan say about how far we take into account cities' limits?
This is Karen Miller. So there's one section or phrase that says generally a mile. But we also have policy areas that are the urban fringe policy areas. And as you know, being on the former Aubrey zoning board, they have the Blue Valley area plan. There's extensive urban fringe areas in that plan. So the kind of the base is a mile, but the county is free to adjust that urban fringe area for the context. And so it can be flexible and can be larger than 1 mile.
Mr. Chairman, I just want to make a note to Jay Leipzig, just in the regulations or the draft regulations that are proposed, item 2D, that just to reiterate that there is a waiver available to that 1.5 mile buffer. And if the applicant wants to deviate from that location requirement, there is a waiver that is available if it can show that it won't hinder the future growth or other factors. So we did want to account for that in the regulations.
My thought is that, and I think the city that would be most affected by any limit that we put here is Edgerton, because of the proposed locations. And Edgerton is a city that really exists to facilitate the intermodal plant and the warehouses that have popped up around it. Other than the old Edgerton neighborhood that has existed for 100 years, everything that's happened in the last 10 years has been exclusively for the purpose of accommodating warehouses and commercial facilities around the intermodal plant. It strikes me that regardless of their claim that they want 3 miles, which would exclude any development, that there's very little of this land that is likely to be used by Edgerton anytime soon. It doesn't have sewers, it doesn't have paved roads, and much of it doesn't. It's not city suitable. And if there is a waiver, the capability of a waiver, so that interrogation could be made of Edgerton by the applicant about what their real future plans are there, not their, grandiose schemes of taking all of Southwest Johnson County under their purview. I don't have a problem with a mile with the capability of a waiver in certain circumstances.
This is Kelly Rass. I feel like by looking at what everybody has said, and even Johnson County Wastewater said that 1.5 miles would be necessary for their recommendations of stuff and be better for what they envision that they will need, then a fair and balanced approach would go do the 2 miles and allow the waiver, because then with that, you can go further down. But if you start at a mile and add a waiver, you can't, it's going to be, hard for people to, or to envision going less than a mile from the city limits. But if you start at 2 miles, that gives a lot of variability for people in certain areas, in the appropriate areas to possibly go down. But also, I mean, I know you keep bringing up the sewers, but have you been to Stillwell?
I live in Stillwell.
Do you have sewers?
There are lots of sewers around me.
Yeah, okay. I mean, I live in Stillwell. I don't have a sewer. It was my first experience with septic tanks. So anyway, I was just clarifying that.
Well, I have
But,
I have a
I
letter
feel like
from, I have a
2
letter from
miles-
Blue Valley wastewater saying that they have no intention of working out in that part of the county at all. They say it's on the other side of the Blue River watershed and they can't possibly sewer it or provide any services out there whatsoever. They didn't express opinion about other potential areas, but that land all drains to the south. And therefore, the Johnson County wastewater has no interest in it at all.
Okay, I would like, to me, I feel like I'd like to make a motion that we do 2 miles and allow a waiver. And then that way they can make judgment calls on specific projects where it's reasonable and works with the cities, Johnson County wastewater to go below 2 miles. But if we start at the minimum, then I'm not sure why a waiver would be needed because you can't really go below what most have requested. That's my thought on it.
This is Mike Levin. I'll second that motion.
Comments?
Mark Huggins. I guess I don't have any objection to that, but I was my idea was that we set up a boundary, you know, kind of like your current development boundary, whereas if it's within a mile of the city, you give the city the opportunity to comment on the project, and I would rather have something of that nature for this, is that we don't say there's a boundary, but we, you know, if somebody comes in within a mile or a mile and a half of a city limit with a proposed utility scale solar use, that the city have an opportunity to enter into the discussion on that. And if there are facilities available or a use plan for that property, then it wouldn't be appropriate. And that it may make it really tough to write the ordinance, but it seems to me like there could be instances where the area within a mile of the city, like for instance, the 2 quarries that are along 56 highway between Cedar Creek and the railroad track and 56, those would not qualify within the mile or mile and a half boundary, but I can't imagine doing much else with those things once they're done quarrying them and they're done with a demolition landfill. It seemed like that'd be an ideal place for a solar field. It wouldn't be at the scale we're talking about, but it seemed like it'd be a good spot. And I'd hate to limit a use like that, you know, might be the only decent use for that property. So I guess I'm not asking you to withdraw your motion, but
Wasn't that when the waiver would come in play? They would go to the zoning board and they'd use the waiver and say, can we go all the way up to a mile? I mean, that's kind of the whole point. Start at a 2 mile, but allow that buffer zone where people can apply the waiver to go even less.
well, my suggestion was no waiver or no buffer. I'm sorry, no buffer, but just an opportunity for the cities or the sewer district to comment on the proposed project, which is kind of the way we handle development now next to the cities.
Motion has been moved and seconded for a 2 mile buffer with a waiver.
Is there something that, so similar to, do we want to just vote on the 2 mile, then with the opportunity to vote on something other
Well,
than?
if I, you know, I hate to do competing motions with a 1 and a second on the floor. But I will tell you that should the motion not achieve a majority vote, I would make a motion for 1 mile with the provision for a waiver.
Jim Neese, I thought the staff recommended the last meeting, they didn't recommend 1 mile, they recommended 1.5 miles.
Yes, but Commissioner Jay Leipzig, in the draft regulations that are before you this evening, staff is recommending a 1.5 mile buffer with a provision for a waiver.
There you go.
Just to be clear on that, that's page 23. It's item 2D of those regulations.
So. Okay, it wasn't a mile, Mr. Chairman, that's fine. That's my point. That they recommend.
I'm aware of what was in the draft regulations. Yeah. Well, you want to do a roll call?
Yes, sir. And this is for 2 miles. So Mark Huggins,
No.
Chris Iliff,
No.
George Lund,
No.
Roger Mason,
No.
Randy Hutchins,
No.
Jim Neese, Dave Johns,
Yes.
Kelly Rast,
Yes.
Michael Levin,
Yes.
Randall Downing.
No.
And that is 4 yeses, 6 nos.
I will make a,
Mr. Chairman,
yes.
I'd like a motion that we recommend what the staff has recommended, 1.5 miles. Yes, with a waiver.
I'd like to make a comment.
Dave
This is
Johns,
Mike.
I'll second that. Oh, sorry, Mike.
No, I just want to make a quick comment about waivers. I noticed going through this, a lot of work you've done, there's several waiver opportunities in here. And just to comment that I think waivers have a place, but I am a little concerned that when you start putting in so many waivers, that it kind of makes some of the actual, if you will, some of the rules or regulations kind of not really that structured, because anybody can put in a waiver in multiple ways. Just making the comment.
Been moved and seconded for 1.5 miles. And again, I would offer that should this one fail, I would make a motion for 1 mile.
All right, Mark Huggins,
Yes.
Chris Iliff,
No.
George Lund,
Yes.
Roger Mason,
No.
Randy Hutchins,
No.
Jim Neese, Dave Johns,
Yes.
Kelly Rast,
Yes.
Michael Levin,
Yes.
and Randall Downing.
No.
All right, that is 6 yes, 4 no.
Very well. The next item is with regard to screening, and I think this is more complex in some ways than any of the others. I don't know how to summarize exactly the positions of the staff and Nextera on this. Perhaps Ms. Miller, you or Mr. Leipzig can try to summarize the differences there.
Sure. Karen Miller. Let me just find my place, please. There we go. So as written, as drafted, the idea is to screen generally 3 things. Existing dwellings, existing residential zoning, and views from public roads. And let me just. And there's a variety of ways that you can do the screening. You can use existing vegetation. You could use landscaping, and part of that landscaping, we give a formula for evergreens and deciduous trees a certain distance apart. We do also allow berming and fencing the intent is that that would not be the primary form of screening, but that would just, if it made sense, like for instance, a substation, it might make sense to perhaps use a berm or a fence in addition to landscaping. And dwellings are also called out as having even more screening within 200 and let me look. Within a certain distance of the solar facility, if there's a dwelling, then basically 100% visual screening would need to occur. Is there any questions about that?
Mark Huggins, yeah, I've got a question. Is this take into account elevation changes and things when you say 100% screening? Are you just saying a allowed screening use between the street or house and the
I think
solar panels?
I think the answer is no. It requires a certain height within a certain number of years, 100%, looking at it perpendicular to it, but it doesn't actually talk about changes in elevations.
Is that, so I'm sorry, is that something that is going to be incorporated into it? Or, because really, I think in practice, screening is a surface area type application. It doesn't really take into account the line of sight, and it can't, honestly. I just.
There was no plans at this point to change that unless it's discussed and recommended.
Okay, I'm not recommending that. I'm just, it sounded to me like that was what was being said.
Honestly, I thought about it and didn't quite know how to do that. So
I agree. I don't think that can be done. Thank you.
Let me ask, is the intention of screening to enhance or maintain the rural character of the area? Or is it to protect against people driving down a gravel section line road from being able to see the photovoltaic panels?
So there's two different types of screening. There's screening the dwellings and there's screening the roads. And I would say that screening the dwellings would be kind of a protective in nature, as you discussed. And then going down the county roads, that's not going to be 100% visually screened. It'd be more of just a distraction. And you're right. I think the intent is to kind of enhance the rural character.
And what about say a half section line road, a gravel road that runs between parcels which have photovoltaic panels on both sides, where there's no potential for offense to the eyes of those who object to such thing? You'd still want some kind of screening along those roads?
The regulations treat all public roads the same.
Okay.
This is Randy Hutchins. I certainly would agree with screening to shield the view from a neighbor's home, provided that they actually want it. They want that screening put in place. The other thing is the screening along the road. I mean, we're talking solar. I mean, we're trying to get sun to the solar panels. It just doesn't seem reasonable that we're trying to create something that would actually obstruct the sun from hitting the solar panels. So That just doesn't seem logical to me, but I'll yield to the fellow commission on that.
This is Kelly Ross. I think just due also to the integrity of that land being rolling hills, different diversity, and the integrity of the nature with all the trees out there, because it is a heavily wooded area, that even if you kept the 50-foot setbacks, you're still only really going to be screening half of them, just because there's no way to screen them, in its entirety, just because of the different heights, depending where you stand. So it seems like a happy medium, a good balance, great guideline.
Jim Neese, this isn't going to be the only one. This is the one of many. Like Randy's talking about some of his neighbors trying to decide what to do. So these things are going to be all over the place. Some of them's going to be on flat ground. Some place going to be so screening is can't disregard it. I don't think.
And Kelly Ross, the other thing is protecting into the future. I mean, we have to protect what comes along in the future, that there's screening from that as well. So of what might come down, or if the area around it grows up, or neighborhood or whatever, no different than we do with a lot of the zoning projects and stuff. So I think it's very reasonable.
Dave Johns, I have a question, probably for Mr. Coffey. There was a gentleman 3 or 4 meetings ago who will be surrounded by what is proposed, the Kanoki's land, and he has cattle there. And he mentioned that it could harm the cattle. Is this something that is proven, or is it just thoughts, or where do we have any thoughts on the cattle that would be potentially completely surrounded by the panels?
There are no harmful impacts that I'm aware of in any of the research where that would be a concern to livestock. I will say, with regard to the screening, I've been listening to the Planning Commission tonight, and you're talking about, wanting the regulations to be reasonable and flexible and pretty minimal, and yet, to achieve the objectives that we're trying to achieve to mitigate the adverse impacts. And to me, this section epitomizes the balance of how to do that. And I think county planning staff did an excellent job in really trying to think this through and figure out how it could be done or not done with the waiver on a case-by-case basis.
Thank you.
Further comments? Hearing none. I assume that is sufficient direction from the Planning Commission, or is there something you'd like to hear from us beyond that, Mr. Leipzig?
Mr. Chair, just Jay Leipzig again, just to make sure I understand, I guess there's no motion to change what is currently proposed. In other words, what is written in terms of the screening with the waiver?
I was going to make a motion. I would do I believe in this, Kelly Ross. I make a motion that we do the 50-foot setbacks and no waivers on that part.
I thought we were talking about screening.
That's correct.
did
This
we
is John
jump to
Penn, the plan staff. I think
setbacks?
we're just on screening. I think the setbacks would be the next issue that we were going
all
to
right.
discuss.
Sorry, my bad.
Yes.
Okay. On my list, the next item is decommissioning and reclamation. Is there a serious controversy here, Ms. Miller?
There was a lot of questions and concerns about the type of surety. And we've asked Richard Lynn, the planning's legal counsel, to be available to address anything that the commissioners would like to ask.
Yeah.
If anything.
My understanding is that there's not really any serious issue between the county and NextEra. with regard to the kind of surety that they would put up to assure that decommissioning and reclamation would take place at the end of the project's term or at the end of the project's life.
Nextera has indicated that they support the staff's draft handling decommissioning and reclamation.
Right.
Mr. Chair, this is Mike Levin. Just a quick question. Maybe I missed it. Was there a time frame on how often that would be reviewed?
Yes.
Was it-
It has to be reviewed at least every 5 years, but no more than once a year.
All right, thank you.
Okay.
Done a lot of reading lately, so.
Yeah, there's a lot of reading. Now, although it's not on my list, Ms. Rast brought up the issue of setbacks. Is that something we want to take up here? And what are the what are the distinctives between the county's position on that and Nextera's?
Staff had not put setbacks on the list for discussion tonight because we had understood that at our last meeting, Nextera had indicated that they accept the staff's 50-foot setback. In Nextera's written comments submitted Friday, I was not sure that they still had that opinion. So
Well, they can make their opinion clear during the public comments. Yeah, but I'm not looking to raise controversies where none exists. So that's, well-
One question, I just, should I go back and make a motion, since I said the setbacks, make a motion that we go back and we accept the staff's recommendations on screening? And that we clarify that? Or we're just agreeing to it, moving forward?
First of all, I think that what the staff was looking for here tonight was guidance. I think that the zoning or the planning commission has given them guidance and a lot to work on before our next meeting, which is a public hearing. That is where a formal vote will be made with regard to recommending the draft to the Board of County Commissioners, who will then act on it sometime later in the year. I want to commend the commission tonight getting through these issues and being able to comment on them candidly and while not always agreeing, nevertheless being able to move forward. Unless there are other issues, I would like to, it's now 8:22, I'd like to open this to the public for public comment.
Mr. Chair, if you just real quick, when it comes, I heard a lot of discussion around limiting chemicals and also what gets planted where, being a Kansas commercial chemical applicator in the state of Kansas, I would like to say that I would leave that up to the professionals versus county trying to regulate chemicals. Further, the farmers and landowners currently work with the U.S. Department of Agriculture. We work exclusively with them today and determine the appropriate cover crop programs that'll work best. So when I see pollinators and whatnot, number one, I see that potentially inhibiting the light hitting the panels. And number two, that does not provide the best soil erosion containment option. So I'd rather the county focus on what the county does best and let the USDA and others worry about, what actually gets planted and ensuring that the right cover crop is planted and maintained.
Thank you, Mr. Hutchins. Moving now to public comment. We're going to give 2 minutes per speaker. I would remind the audience that we have had 3 prior meetings at which public comments have been taken. And therefore, I would ask that those who come before us, if you've been up before us, to not repeat what you've said before. What you have said was heard by us previously and is part of the minutes. So we will go ahead and start with public comment at this time. Ms. Davis, have you got your list? Yeah, let's start with Zoom.
All right, our first speaker to sign up today was Bill Tillman. Bill Tillman, you should be able to speak now.
Yes, how is everyone tonight? Can everyone hear me okay?
We can, Mr. Tillman.
Okay. I'm not sure if I'm thinking my question is more for the Board of County Commissioners, but you know, I've sat through this. This has been very interesting. So my question is, if this project gets approved and this goes forward, does NextEra have a contractor already planned to build this, to do the construction? Or are they planning on putting this up for bid for our local contractors? And the reason I ask is, I would think that landowners in the county and NextEra would have an interest in putting its local contractors and that local workforce to work. On this, my understanding, this is about a $320 million project. Generates about 250 construction jobs. So it would be nice if local contractors get the opportunity to bid on this. And local workers, you know, I think if everybody's serious about making an investment in Johnson County, it'd be nice to start at the bottom with the construction and invest in that local workforce and those workers. Those people, they live here, they work here, they pay their taxes here. They shop here, their kids go to school here, they support their local businesses. So I just think it makes good sense and it's good for the community's well-being. So that's pretty much all I have.
Thank you, Mr. Tillman. And if representatives from NextEra are here tonight who would like to answer that question, they'll get an opportunity to do so. So hang in there.
Okay,
All right. Thank you.
thank you.
All right, our next speaker in person is Carlene Thompson. Carlene Thompson. Are we doing that? Oh, okay.
She's just passing.
Okay.
Yeah.
Our next speaker on Zoom is Robert Wright. Robert, you should be able to speak now.
Yes, thank you. This is Robert Wright with Burns McDonnell. I am our Renewable Energy Development Manager and speaking on behalf of Burns McDonnell tonight. So while Burns McDonnell is headquartered on the Missouri side of Kansas City, myself, along with a large portion of my coworkers, do live in Johnson County. What I would like to address is just some of our technical experience as it relates to the conditional use permit duration. So not offering an opinion on any of the other aspects that have been discussed tonight. So while Burns McDonnell is not directly involved in financing of solar projects, in our role as engineering consultants to various utilities and developers, we have evaluated a number of solar economic models. Solar projects are generally selected based on fairly small margins compared to both competing sites and alternative options. And how these projects are financed is a large piece of the overall economics. A conditional use permit valid for 20 years may create a financial hurdle for solar projects in Johnson County. Most projects are financed and evaluated over a minimum of 25 years, with many of our clients evaluating over 30-year or even longer terms. So limiting the certainty of these projects to 20 years could push owners and financial institutions to consider economics of solar projects over just these first 20 years of the project life, which is likely to negatively impact the economics of the project, ultimately reducing the ability to finance solar projects in the county. Thank you.
Thank you, Mr. Wright.
All right, our next person to speak in person is Jane Kanoki. Jane Kanoki.
Good evening, Jane Kanoki, 23535 West 74th Street, Shawnee, Kansas. It was good to hear a lot of the discussion tonight. And one of the things that really struck me was significant competing land uses in Johnson County. So I'm a 5th generation Breck-Eisen. We've had the land for 150 years. If you would divide 150 by 5, that's 30 years. Now that to me would seem to be a generational golden cycle, not a 20-year Johnson County city-based golden cycle. So I ask you to think a little bit more about agricultural land use cycles. My mother, Donna Kanoki, lived there in the Breck-Eisen homestead. And in 1947-48, she told you that's when electricity came to them. That was 70 years ago. And that we've had the land for 80 years. So this is a very much a different type of land use and agricultural thing. Electricity didn't get there as quick as it did in the cities. So I ask you to think about that, to take that contrast. And remember, you're talking about rural agricultural Johnson County. 3% of the 144,000 acres that is unincorporated and not being called for use. So I'd like you to think about that. I'd also like you to put the perspective of a cell tower cost about $1 million to build, and you permit it for 10 years. This project is about 460 million, I think. And you're only saying 20 years, big capital investment difference. So please be mindful of that and these differences as you're comparing apples and oranges. And thanks for your time and thanks for your volunteering to do this. I really appreciate that.
Thank you, Ms. Kanoki.
All right, our next speaker is on Zoom, and that is Stephen Clark. Give me just a minute. His name is listed twice, so hopefully there's no technical difficulties. All right, Stephen, you should be able to speak at any moment now. Stephen Clark? All right, we must have lost him. The next person in person, the next speaker in person is going to be Donna Kanoki. Donna Kanoki. All right. Then the next person we have on Zoom is Marvin Kanoki, who is now gone. So the next person in is Stan Kanoki.
Hello, I'm Stan Kanoki, 8708 West 82nd Street, Overland Park, Kansas. We are turning a new page in the energy sector. Renewable energy is the future. Solar is one of the cleanest source of energy, no carbon emissions, minimum noise, and no smell. Critics say, what about the carbon emissions when installing the panels? I say, what about all the carbon emissions when planting seasons arrive, disking, tilling, planting, and harvesting? These steps occur every year. Once the solar farm is created, the carbon emissions would be reduced to a fraction of almost zero after installation for this land. There's a similarity of solar farm and to farming. Farming, you're harvesting crops, and solar, you're harvesting energy. Both use the sun. Whatever happened to the landowner's rights, we feel we are looking to the future with our lease agreement with NextEra. I think we should be able to accept this business opportunity to help secure a reliable energy source. This opportunity would secure our land for the next generations. My grandfather was a pioneer settler on this land before Kansas was a state. We hope to be the first pioneers in the solar project expedition in Kansas. Listening to a K-State fertilizer commercial from the football game, the announcer said to get the most out of your land and a higher yield. Nothing produced in the past, corn, soybeans, wheat, hay, or cattle, can bring in as much money as solar energy for this land. For the landowners who lease to the NextEra in the West Gardner Solar Farm want to pass this land to their future generations. All this while supporting a healthier future for people and the planet. Most of this property is already fenced. That should be the setback of the barrier line. Any fencing should be security fence with discretion from NextEra. For me, solar panels don't look bad to me. Thank you.
Thank you, Mr. Kanoki.
All right, so Mr. Marvin Kanoki has joined us. And you should be able to speak now, Mr. Marvin Kanoki.
Hello, Board of Planning Commissioners. My name is Marvin Kanoki. I live at 1605 West Maple Street, Nevada, Missouri. I was born in Johnson County, have lived in the county for over 65 years. I believe in landowner rights and green energy. Our country will always be needing electricity. The Midwest is the least polluted air and water area in the United States. This is one of the reasons why I love being in the Midwest. I believe that our family has done an excellent job in maintaining and preserving this land. I firmly believe that a solar farm will provide electricity for the Midwest. This will allow for future population growth in our county. In order to increase this electricity, we need to allow regulations be adopted that are favorable to these projects. In the solar industry, a company invests millions of dollars. Thus, they need a favorable period to break even. The operation of a solar farm needs a CUP at least 25 to 30 years, and the panels are warranted to produce power for at least 25 years. I strongly recommend the board to put the regulations into place that provide for this. Thank you for your time and listening ear, Marvin Kanoki.
Thank you, Mr. Kanoki.
All right, our next in-person speaker is Sharon Green. Sharon Green.
Hi, my name's Sharon Green. My address is 38225 West 159th Street. We are the 10 acres next door that Kelly was talking about. Am I not an agricultural person? We are just two retired adults trying a hobby farm. I moved here in 1955 to Johnson County with my parents, and we lived on 87th Street, and behind it was all farmland. In 1978, we moved to Olathe, and there was a truck stop off I-35, if you remember, and it was farmland. In 1999, because it was so crowded in Olathe, we moved out to this new address, and we have lived there happily with it growing, and we know it's growing. Is it going to be farmland forever? I doubt it. We know what happened in Olathe. So I would say if it changes, we have to adapt. Do I like the idea of solar panels? Yes. But do I like the idea of solar panels here? No. We live next door. I know about the erosion. I know about the flooding. We live in a smaller area that is on a 100-year floodplain. In part of the 10 acres, it has flooded every single year.
Sorry.
And so my question is erosion? Yes, we have erosion. Yes, we deal with it. Yes, we deal with land settling and everything. And there's acreages that are just so flooded. You have to consider what's best for the country, and the county rather must not make other people adapt to solar paneling if they don't want to. It's not a can or cannot. It is a must. For some people are forced into it. And that's my time's out. I thank you. And I know you know that I was nervous and scared because I don't do public speaking, but thank you.
Thank you, Ms. Green.
All right, Mr. Stephen Clark is back with us through Zoom. And you may speak at any time, Stephen.
Good evening. Thanks for taking my call. My name is Steve Clark. I live at 3422 Kensington Court in El Dorado Hills, California. I strongly support responsible and beneficial solar project construction in Johnson County with reasonable and fair zoning regulations, similar to those adopted for the other 1,000 plus operating solar farms across the U.S. Zoning regulations should help protect the public and lands within the county while also allowing beneficial development. The draft solar zoning regulations include many protections for stormwater runoff, noise, fire protection, facility decommissioning, and more, which will absolutely protect the public and environment. While that's good, the draft regulations also include several unique, overly restrictive, and costly criteria not adopted by other planning authorities. These include the short term, minimum distance from cities, and visual screening along rural roads. No other county requires these zoning restrictions for solar. Johnson County zoning regulations do not apply similar restrictions against any other type of development, just solar. The most impactful draft restriction is likely the conditional use permit term of only 20 years. To my knowledge, no other county in the country has issued a CUP for a solar facility for less than 25 years. In comparison, no hospital, warehouse, or office park in Johnson County has a limited life permit. Would any of those have been built if they were limited to just 20 years? No. It doesn't make any economic sense to build an expensive, long-lasting facility for a short time. Why is solar singled out for a 20-year permit when solar panels last longer than 30 years? Johnson County has allowed a wide variety of other facilities. Why not solar? They have virtually no power plants built in Johnson County. Electricity is all imported from power plants located elsewhere. I believe solar farms are an appropriate, beneficial, and necessary land use. Zoning regulations should not strangle it. Thank you.
Thank you, Mr. Clark.
All right, our next speaker is Trent Green.
Go back to the picture. I want to see.
Ladies and gentlemen, it's a pleasure to be here, even though it's very, very different for us. We don't normally get up in front of crowds and talk. I'm pretty simple when it comes to what I believe in, and that's what, first of all, brought us from Olathe out to 159th and Edgerton Road. We are, as my wife said, right next to where the planning is for the north end, literally a tree line away. my concerns is we are actually McCambish Township. Has anybody ever taken that in consideration? We have an Edgerton mailing address, but we're not really in Edgerton either. We are McCambish Township. We also have, as my wife said, experienced problems with flooding. And it's a yearly task that we have to work ourselves around. Also, I don't know if you're aware that the California and Oregon Trail cross right on our property. We have a big solar field next to us. Mom and dad are not going to jump out of their car and say, there's the California and Oregon Trail. They're going to say, you have a solar array where this goes through. I really hope that you give this some really serious consideration, because you're talking about numbers of families that are going to be, going to be displaced or are going to have problems with this, both economically as well as their own fiscal responsibilities. And I thank you very much for listening to me, and thank you again.
Thank you, Mr. Green.
All right, our next speaker, Dr. Robert Kanoki.
Want to thank the board here for coming up. I've kind of wasted the last two meetings hearing everybody talk and not finding out how you feel about it, but I appreciate all the work you've done on it. And I know what it's like to come up to a meeting every twice a month. I was on the Soil Conservation Board in Johnson County for about 10 years, on the city council in Gardner. Did get paid a little bit there. It was very minimal, nothing on the other board. And I thank you for your time. Thank you.
Thank you, Dr. Kanoki.
Our next person to speak is Richard Gall. Richard?
I take the privilege of saying that Mr. Galt consulted with me. He's going to read a letter until his time is up, and he wanted you to know that it would be available for reading online. He will submit it to staff so that they can make it available to everybody.
And I've kind of edited some of it. The last meeting, a person asked if electricity from solar project was going to stay in Johnson County. I want to let you know that the people that lived in Johnson County that were customers of Kansas City Power and Light did not use electricity that was produced in Johnson County or even in the state of Kansas. The first power plant KCP&L built in Kansas was at Lacine in 1973. The power from that plant, like other plants, is shipped by a 345,000 volt power line across the country. We have some friends that live 3 miles west of the Lacine plant and tell me that there are times when the dishes in their cabinet rattle from the vibration of the power plant. We also found information that the Lacine plant is rated the 16th worst plant to produce contamination in the air that is harmful to humans. The next plant KCP&L built in Kansas was Wolf Creek Nuclear Plant at Burlington. 9,818 acres of land was used for this plant. That includes the lake where the water comes from to make the steam to drive the generators. If the lake gets low, water is pumped from John Redmond Reservoir to take care of that problem. Another comment was that people don't like to have to look at the solar panels. Like I said at one of the meetings, to me, it's a way to produce much needed and wanted electricity. Having been one of the great number of people that built and maintained power lines to the people that were customers of Kansas City Power and Light, I have asked several people, and I will ask the commission the following question. Of the necessities in life today, where would you put electricity? The answer is always pretty high. I think most people would agree with that answer. The list of things we need to have to use electricity to be able to do is very long. That need will get much larger when electric vehicles become more popular. We have an all-electric home, so we use electricity for everything. People that heat with natural gas or propane need electricity so the furnace fan can blow the hot air through the duct lines into the rooms of the house.
Mr. Galt, your time's up.
Oh. Do you have time? Do I have time for a funny? You know what the biggest cause of dry skin is? A towel.
I couldn't stop you.
All right, our next speaker is Travis Hardy.
Travis Hardy, 421 East 2400th Road, Edgeworth, Kansas. There's a couple of things that have not been mentioned that I want to bring up. One being, these facilities are going to have cameras on them. There needs to be rules about these cameras cannot point to anybody's property that is not part of this. They can't point to my property. It's invasion of privacy. I would like that to be put into the regulations. Secondly, there's also the talk of you got to clean these panels. It's going to use water. Our water table in Kansas continues to go down. This is a big concern because this facility is going to be so large. This really needs to be looked at. There needs to be regulations around it. Farmers have regulations around irrigation. That needs to be part of this as well. Another thing that there's a possibility this can interfere with signals out where we live. I can tell you, it's almost a dead zone. And if this is going to interfere at all with cell signals, that's going to be a huge problem, and that needs to be looked at and make sure that doesn't happen. I would also like to say, as citizens, as other cities, we have sent in numerous things. We have talked many times, and at this point, this whole process seems like a failure. No one listens to our words. Everything that's been put in this proposal, none of it's been anything we've wanted. It seems all one-sided. We talk about, well, Nextera said they'd agree to this. Nextera agrees to that. Well, what about us? Why are we not being heard? Why are no concessions being heard from us? It'd be nice if something that we want would come into this, but instead it's all Nextera, Nextera, Nextera. We're the ones going to live out here. There may not even be revenue really generated from this for quite some time. And yet we're so willing to move forward on this and not even listen to the people living here, even the cities that have problems with this. You really need to change this. I wish you'd start listening to us and change the direction. That's all I got.
Thank you.
All right, our next speaker is Alan Anglin. Alan Anglin.
Alan Anglin, 17090 Evening Star Road, Edgerton. I'd like to echo something that Travis Hardy just said, and that is that there's been a lot of focus tonight on what does Nextera want? How do we make Nextera successful? And then there's been others have commented, we're not here about one particular company. Nextera is not the only solar company that's out there. There could be potential other applicants. There are many applicants that can build solar farms that aren't so massive, that don't require all the things that Nextera says that they must have. Let's look for a moment at Burke County, Georgia. Nextera recently put in a utility scale solar facility there. Burke County's population is less than 25,000 people. Unlike Johnson County, Burke County is a rural county with limited growth. Burke County solar regulations include the following setbacks: a minimum setback of 300 feet from adjacent properties with residences, to include a dense vegetative buffer of at least 100 feet. And that's not from visibility from the house or the residence, that's along the entire property line. And for adjacent properties without residences, a minimum setback of 100 feet with a dense vegetative buffer of at least 75 feet. Even with these setbacks, Nextera put in a utility scale solar facility that was only 500 acres and conformed to this. They found a way to adapt. Obviously, they're going to make money at it. They wouldn't invest in it otherwise. So rather than listening to what they say they must have, I urge you to look at their actions. In places like Burke County, Georgia, in places like Florida, their home state for most of the solar farms are between 500 and 1,000 acres and are 74 megawatt facilities. But $18 billion a year in revenue, $3 billion a year in profits, they're doing quite well. Johnson County has zero responsibility for profitability of an out-of-state big energy company. We, the residents of the county, look to you to keep Johnson County an attractive place to live and work. Thank you.
Thank you, Mr. Engelmann.
All right, the next speaker, Donna Gall. And the next, Bernadette Anglin. The next speaker, John Peterson.
Thank you, Mr. Chairman. John Peterson on behalf of NextEra. I'm going to move very quickly. Thank you for the robust discussion tonight. Helpful. We'll be providing written commentary as we approach the public hearing. Let's talk about two primary components, term and size. I'd like to address a suggestion that's been made that this is about how much will NextEra or any participant in the industry make? Will they make this much or that much? Not what it's about, ladies and gentlemen. It is about, can a project start? It has to be a size to produce enough megawatts that there's a market to buy the power. It has to be in place for a term sufficient that power purchase agreements can take place. Then utilities in turn can make the decisions to move back from fossil fuels, which in fact, it also is a long-term decision. We came to these working with staff with that in mind, a compromise that will work, a compromise that can be financed, but it's not just how much or how less this particular or any company in the industry would make. It's about starting. Is it viable? Heard a lot tonight on the various other issues. There were several key issues. Mr. Coffey spoke to, well, the reason we're proposing setbacks, buffering, some of the other elements is because the urbanization of the county. I stand here tonight, at least in terms, and it speaks to why there ought to be flexibility and analysis of the projects themselves. The area of West Gardner is not an urban area. It is not an urbanizing area, and it won't be an urbanizing area for a very long period of time. Spoke to it tonight often about, will infrastructure ever get there? In fact, I would suggest many that oppose solar applications will just as strongly oppose the urbanization of their area with sewers and water. Distance from cities, we stand on the comprehensive plan. Setbacks, I think we can work with for most part, but you make our acreage smaller, it puts pressure on those setbacks. And finally, screening, urbanization. Houses will screen, of course. Buildings will screen, of course, but to put an urban level of landscaping along streets and boundaries, as Commissioner Huggins says, you're still going to see the project. Thank you.
I would ask the people outside of the room to be quiet and be respectful of the speakers in the process. That's enough. Everyone gets to be heard, and I give a little grace time for everybody, regardless of their size or side that they're on.
The next speaker is William Wilkins. William Wilkins.
Good evening, Billy Wilkins from NextEra. I'd just like to provide a different perspective a bit. So this is an opportunity for the county, for landowners, for local suppliers, contractors, and for NextEra. When constructing a project, we first look for the opportunity to hire local contractors, infusing economic benefits to the local community. Property value, I'd like to talk to that a bit. Opinions versus data. There's no evidence to indicate a solar project will impact neighboring property values. A 2018 study by Cone Resnick, which is a Chicago-based firm that specializes in property valuation, looked at home sales in proximity to 6 solar farms across several states, and it found no measurable impact on property values adjacent to solar farms. Now, echoing Mr. Kofi's from the Berkeley Group about term, and I know Mr. Peterson talked to that a bit. We've never seen a county with a set term for a CUP for our projects. It's not about whether it will be renewed sometime in the future. It's actually not about profitability either. It's about the risk the term provides or poses to the potential project now. The risk potentially jeopardizes the ability of the project to be contracted with a customer and to be financed by a financial institution. We enter into long-term power purchase agreements that can range from 15 to 30 years and financial institutions analyze the economic viability of a project and through their diligencing process, determine if they can finance or will finance and what the cost of that financing is. Now, our proposed project will provide power to Johnson County. The project would interconnect at Evergy's West Gardner substation, and it will enter the grid there and be distributed through Evergy's distribution network. Electrons will go to the first point where they're needed in the county. And we're just asking for parity and for our proposed development to not be exposed to selective limitations. Thank you for your time.
Thank you.
All right, the next speaker we have is Rob McCollum. Rob McCollum. I don't see anybody moving. Okay, the next speaker would be Sharman McCollum. Okay, and I'm assuming they left. I had another person sign up through Zoom, and now that we're done with the first page of in-person, I'm gonna call on them. Victoria Huser. Victoria Huser, you are now able to speak. All right, we're going to move on. And the next person to speak is Carol Hatfield. Carol Hatfield. All right, we've got somebody coming in.
I have lived in that area for over 70 years. I grew up out there.
Would you state your address, Ms. Hatfield?
My address is 37275 West 151st Street.
Thank you.
I'm right up from Edgerton Road. Anyway, you guys have not informed any of us that this was happening. I wouldn't have known nothing about it if I hadn't gotten a letter from a lady out there. And I think that is sneaky and it's not right. And the other thing is, I have always been told by the county commissioners that they want to keep it a green space open to everything. And anything I tried to do out there, like having 80 acres over by the sunflower plant, I tried to split it up. They wouldn't let me split it the way the land needed to be split. Then I went back again and reapproached them, and I finally got it done the way the land needed to be done. But, you know, it cost me double to get that done. And you guys don't take in any consideration the people out there. I have friends that live in Overland Park who will not come out and see me because they say it's too far to drive, but they expect me to come in and see them. And I'm sure all you people probably live in Stanley, Overland Park, or Leawood, and you have no desire to drive out there. You don't know how it is to be in the country. It's dark at night. We don't have all the lights and all the fancy stuff, but you guys seem to not give a damn, basically. You just want to do whatever you want to do because of the money. Why not put it on the sunflower plant? They can clean it up, this company can, and they can do it. But, you know, you guys are going to have a park around the outside of that plant. And you expect people to pay for your 9,000 acres over there. Why not get them to go over there and use that area because it's already contaminated? These batteries and solar panels that they're going to have, they're going to contaminate the land, they're going to contaminate the water, and they're going to hurt the livestock. And like I say, you guys don't care about anything. And that has been there for generations. And I know my time's up. So anyway, I'm just telling you, don't do this. It's not right, and you shouldn't be doing it. But you need to take a trip out there, get in a bus and go look at all the ground out there and see what it's like.
Thank you.
All right, our next speaker is Cindy Fitzgerald. Cindy Fitzgerald.
Me too.
That last speaker just awesome.
I don't care what side you're on, but she's just not incredible. You guys agree? Okay, good. Hi, I'm Cindy Fitzgerald. I live in Edgerton, Kansas, 254 East 2300 Road. We raise performance horses, and we're going to be 1,900 feet from this. So you can understand the people out here and everyone that lives in this area, how concerned we are. We don't want to live next to this. For every study that you can produce that a solar farm does not affect land values, I'm happy to email you two that show that it does. Also, Walmart and Amazon took on Tesla and their batteries because of the fires that they incurred in their facilities. Walmart dismantled and took away the solar off their roofs because of the fires that caused damage to the firefighters and also to their employees, plus the toxic smoke that happens when these catch on fire. If a tornado comes through or 80, 70 mile an hour winds, as you know, we do experience, destroys one of those solar fields, all those chemicals, and I believe they're called PSEAs, they're called forever elements, they never leave, will go into the ground, and that ground is useless for pretty much ever. Also, I live on the aquifer, that wonderful big aquifer, and I have our water tested, and we have pure, wonderful water. If that aquifer is contaminated, we're done. I mean, we can't live there. I can't water livestock. My brother, I spoke with my brother. My brother his firm was the lead attorney in the Monsanto case and the chemical spill in Houston, Texas, that the whole community was affected. Cancer, a lot of deaths, children. I mean, it was horrible. And I asked him, I said, what can we do? Can we sue? Can we do a class action lawsuit? He said, Cindy, by the time that happened, there's so much damage and devastation and death and destruction, and your environment is destroyed. All the money in the world isn't going to make it whole. If I'm asking you, would you guys want to live next to this? No, the Kanokis don't live next to this. I know Breckheisens that will be living next to this, and they don't want this project. It's all about money. Don't look surprised. I know all these people that are involved in this. So I just ask you, please that's why the emotions are so high, and think about it.
Thank you.
All right, our next speaker, A.D. Shafee.
Hi. My name's A.D. Chaffee. Most folks call me Geezer. I've heard a lot of stuff tonight. And I've got a question for anyone on the board. Can anybody tell me, were you required to take an oath of office in order to occupy that seat? Yes or no? Nobody knows?
This is your opportunity to address us, not our opportunity to answer questions. Thank you.
Well, that's a question you need to answer. You need to answer it right now would be the best time. There's a couple of things that I have noticed. I don't come here arbitrarily harboring animosity for you, but I definitely don't have much use for incompetence. And what I've seen here tonight would demonstrate a complete absence of knowledge of what your job is. Has anybody here ever read the Declaration of Independence or some small portion of the Constitution, or perhaps a little tidbit of the Federalist Papers? Your job's very simple, and it is to secure the rights of those people out in that hall, period. That's it. That's the only reason you're sitting there, and it's the only concern you have. What Nextera's problems are Nextera's problems. They are required to solve them themselves. End of story. You are not required to solve them, and pretending as though it were any portion of your concern. Has anyone on this board asked for the Johnson County Commission to cite the article, clause, section and clause of the Kansas Constitution that gives them the authority to even contemplate such foolishness as this being perpetrated against the people of Johnson County? That's it. I'm done.
Thank you.
All right, our next speaker is Joyce Whittier. Joyce Whittier.
My name is Joyce Whittier. I live at 7414 Flint Street in Shawnee. I have a BA in legal studies and a paralegal certificate from Webster University. I worked in the legal field for more than 40 years, and all of it involved litigation. Your reliance on Golden shows a basic misunderstanding of how the law works. Precedence is, in order, federal, state, county, and local, and precedence goes down, not up. The Kansas Supreme Court required six issues to be addressed, all concerning the impact on property values before any rezoning could occur. None of these have been addressed. The staff has been talking behind closed doors to NextEra representatives since November of 2020, with no input from the public until August of this year. This is a violation of our due process rights as set forth in the 14th Amendment to the U.S. Constitution. According to Rick Lind, the public should have been involved from the beginning. The November 2020 minutes mentions a meeting between Sean Pendley and NextEra. The minutes of the September 28 meeting shows that Karen Miller met with, and quote, 3 people and then 2 landowners who were on the board of the Johnson County Farm Bureau and also farmers. Both of these are considered ex parte communications, and the dates and content of what was discussed should have been included in the minutes. Failure to do so is a violation of the Kansas Open Meeting Act. There may also be conflict of interest on the part of one or more members of this commission. For all of the above reasons, you are legally barred from approving the application until all these violations have been addressed and remedied. I would like to add for the record that Darren Coffey is a co-owner of the Berkeley Group, and his title is Director of Strategic Partnerships. He is not an independent consultant. Thank you.
Thank you.
All right, our next speaker is Charlotte O'Hara. Charlotte O'Hara.
Charlotte O'Hara, 15712 Windsor. This is a big step for Johnson County, and I appreciate you taking the hours and hours and hours and hours of time to listen. As you know, I've been in the construction business all my adult life. I'm not in it currently, but I do own industrial buildings in Olathe. And I have watched this county grow and develop. And what we're thinking about is going to have a huge impact on the future growth of this county. And I think most of you on the board realize this. We have never, ever, ever, ever considered something that would be a barrier to the natural development of the extension of those cities. And I hope that this will not become the Great Wall of China, but will it? You're putting out this huge solar farm, or the planning for regulations for a huge solar farm. And this is really changing the trajectory of our county. We are an urban county, and we know how rapidly we have been growing. I do really, really commend all of you for all of your time and your effort and your study. But as we go forward, please be cognizant that this is brand new territory. We have never done this before. And I want to mention something about the Lacine plant. I'm from down around that country. I was born down in Bourbon County, which is right next to Lane County. And I know some folks up there, and that plant provides 70% of the county's revenues, schools, the town, and the county itself. We need to be careful about how we talk about our neighbors and all that they bring to this county, because that power plant has been a tremendous asset to us. And it is not a huge polluter. They have spent many, many, many millions of dollars on it. And thank you very much.
All right, and now we have Barbara Kerr. Barbara Kerr.
Thank you for hearing me. I live at 583 East 2300 Road. And I represent the Citizens for Responsible Solar Development, representing both Johnson County residents as well as Douglas County residents. When we first heard about this project, and the vast majority of us only heard about it in September, we were shocked, simply shocked that a program could be in the planning, a project for 3 years before we knew about it. Not good. Anyhow, I simply want to say that I'm a psychologist, so I look at process. And the process that I've noticed is those of you who speak positively about this project, about NextEra project, tend to be those who quote almost directly from the NextEra website. I'm also a researcher and I can read data as well. And it is very clear that the kind of figures that NextEra presents, such as minimal property value decline, are simply the manipulation of statistics. Most of the studies, in fact, the largest meta-analysis that was done, look at the change in property values between 0 and 5 miles. Now, once you get past 1.5 miles, you tend to get negligible change. But the changes at 100 and 500 feet range from 20 to 37% decline in property value. If you had realtors who had known about this, and none of our realtors knew about it, I think they would be shocked at this. So I'll just give you this detail about us. We have 200 homes within less than 1 mile of NextEra's proposal. It is not true that there's nobody out there. The development footprint of these 200 homes alone have property values in excess of $80 million. Please listen. Then my opinion, I think NextEra is the Tyson chicken of solar industry. We need responsible solar industry.
That's all.
All right. Mr. Leipzig, anything further?
Mr. Chairman, thank you for your time this evening. I appreciate it. We do have the public hearing scheduled for November 16th. That I have the direction that we needed.
Okay. Thank you very much. This meeting is adjourned.